May pleasure lawsuit. My lord, I beg to mention item 28. Let the matter be listed after vacation. 28.
Yes, paid for by Mrs. K. Devi, learned counsel for the petitioner. With the matter again after the exchange with the petition.
May I please, Your Lordship? One item, Your Lordship, it is listed before the Honorable Court number 9, Your Lordship. Honorable Justice R. Pukon, Your Lordship. However, the bench is not sitting today. This was for consideration of interim prayer, Your Lordship. May I pray that matter be taken up tomorrow, Your Lordship? Otherwise, these cases are deferred by the, as per the notification issued by the registry, Your Lordship.
Which item is that?
Item number 3, Your Lordship. Haridhan Lahpur, Your Lordship.
All right.
Tomorrow.
Same prayer will be listed for item number 27 of October 9.
27. Okay. Okay.
Same prayer, my lord, item number 26, my lord. Urgency is there, my lord, kindly tomorrow, my
Okay.
lord. I have also same prayer, item number 5.
The entire list goes, will come to this court.
Item 5 of court number 9.
Okay.
I have item number 2 lost it, report number 9.
Is there urgency?
Lost it Friday,
Hmm?
Friday. Friday,
Friday not possible, last day.
or tomorrow.
Tomorrow we'll see, okay? Friday, we want to be a bit light on Friday.
Please, Your Lord.
Yes.
I beg to mention for listing of the matter, Your Lordship, motion matter, Your Lordship. So suspension matter on 19, Your Lordship.
Friday.
My Lord. Motion matter, Your
How many
Lordship.
matters are there on Friday?
My motion matter, urgent matter,
Have you filed
suspension.
it?
Suspension.
Have you filed your case?
My Lord,
When?
I have already filed on 15, Your Lordship.
What? All right. We'll list it tomorrow or day after tomorrow, okay?
Bye.
Depending on the workload. Motion matter urgency is there?
Yes.
All right. I'm not giving a fixed date. It may be either tomorrow or day after tomorrow. Okay?
May I please, Your Lordship? Not the same, a similar prayer, my lord, for listing for motion, my lord.
Okay. Motion, right. All motions allowed.
May it please your lordship.
All motions are allowed. Don't give a date. It may be tomorrow or day after, one of these dates.
May it
Alright.
please your lordship. With the consent of the other side, I beg to mention item number 27. If some personal difficulty, matter may come up after vacation, lordship.
You're for the
Petitioner, lordship.
item 27. Okay, as paid for by the Honorary Council for the petitioner. Petitioners, are not objected to by the other side. This again after the ensuing vacation.
Much.
My lord, with the consent of the petitioner, my lord, I'm mentioning item number 32. Let this may come after vacation, my lord.
32. All right, same order. This is on the prayer made by Mr.
Our government,
Adhar, learned counsel for the
respondent, my lord, tribal affairs.
respondent tribal affairs department. Give a date for all these cases. All right. 32 will be on which date? 22-1 and one more date, 27. 27, item 27 on 8-1. Item 32 on 22-1. Yes,
May I please? Actually, I'm praying for listing of tomorrow or day after tomorrow some orders column, lordship. All matter pending, lordship. Urgency, there, lordship.
all matters you approach the registry.
Only, lordship, one observation is required.
Maybe. I'm not entertaining. You know very well.
Yes, I know, lordship.
Please
it's a
approach
motion
registry.
week, lordship. Still, lordship,
This week only 2 days remaining, so we'll have only motion matters, only
Yeah, but-
urgent matters.
immediately after the reopening, lord, I'm giving.
You approach the registry, given the registrar.
Registry, lordship, that may not come, lordship.
Huh?
In registry, lordship, I have earlier also approached, lordship, it is not
How
coming.
did you approach?
By, lordship, giving application, lordship.
You give application plus you have to write, there's a registrar there. Note it down on the registrar.
Lordship.
All right, next.
My lord, what is happening? Earlier, I was filed, my lord. for amendment of the writ petition to the extent of amending the prior portion, my lord, I was filed. And lordship, there were certain mistakes, my lord, and lordship asked to withdraw the matter, and file afresh, my lord. And that has been numbered, that may be allowed to come up on tomorrow, my lord, day after tomorrow.
Do tomorrow or day after, any of this, I'm not giving you a date,
Give
okay?
me a break.
Yes,
May I please lordship, I beg to mention item number 2 and 3 of daily list. The matters may be adjourned for the day.
2 and 3.
Yes,
You're for the petitioner.
yes.
On the prayer made by the learned counsel for the petitioner, matter stands adjourned for the day. 2 and 3.
Your Lordship, I beg to mention for listing one I on for order on their
IA for what?
for bringing record the record the residential address of respondent number 5 in WPC 6272.
IA first time,
I first time.
first time.
First time.
Okay, any of these days, tomorrow or day after.
Tomorrow.
Lordship, I beg to mention item 8, Your Lordship.
Yes, item 8,
This matter may come after vacation, Your Lordship.
as paid for by Mr.
Came
K. Mira, learned counsel for the petitioner. This is the matter again after the ensuing occasion. Also, it's, give a date.
May I please your lordship, I beg to mention for listing on WBC after vacation lordship. One for admission column.
Please approach the registry. They'll look into it, okay?
My
Next,
Lordship,
Hmm.
actually, with mention item 11, Lordship.
yes,
We are supposed to file an additional affidavit, bringing some new records on record,
Hmm.
but we need some more time, Lordship. So kindly matter be taken after vacation.
okay, as paid for by learned counsel for the
Petitioner.
petitioner. Matters, petitioners. Matter stands adjourned to be listed again after the ensuing vacation on so and so.
And secondly, Lordship, I had to mention for matter, Lordship, for withdrawal, Lordship, can be tomorrow, Lordship,
Yes, okay.
of Lordship.
It's your lordship, may I beg to mention IA for listing. Lordship, can it be right after vacation on 6?
What matter?
IA.
What
For
is IA?
non-payment of salary, lordship.
IA,
Yes, lordship.
new case, new application.
Yes, lordship.
When did you file it?
15th, lordship.
15th. You have the filing number and all that?
Yes,
Mention memo.
lordship.
Okay, what must I give a date?
May
Yes.
please, Your Lordship. Lordship, item number admission 22, 23, and 25.
Yes,
Well, these are the 18 matters. We petitioner praying for re-scrutiny of the scanning committee and 80%, but already they got the appointed as a tutor. So
Okay.
I may be allowed to withdraw the all three, my lord, except 24. I'm not 24.
oh, 24 you're not withdrawing.
I am not in the case, my lord. 22, 23, and 25, my lord.
Okay, Mr. N. Bora, learned counsel for the petitioners. In item number 22, 23, and 25. Please note the case number, okay? Submits that the petitioners have got the relief and therefore they would not
Some
like.
of the petitioner, all petitioners.
Submits that some of the petitioners have got the relief and therefore they would not like to press the matter.
And the liberty may be given if so advised, my lord. If they can be put down, liberty may be given if advised, liberty, my lord. Because
If
some
you've
of the,
got the relief,
because
what
I have
liberty?
no communication at all, my lord, that's why. my lord. As per instruction, they, earlier, my lord, they got, my lord.
And therefore he may be allowed to withdraw the writ petition with liberty to file
Right.
afresh,
My lord,
if side by side.
my lord, my lord.
In view of above, the writ petition stands disposed of as withdrawn with liberty. That's not wrong.
Much blessed.
Daily list item 1 for motion.
Moniza, I've given you the item number, no? But when you type out the case number.
In this manner, affidavit has already been filed. Let this matter come up for admission.
Which item?
Item number 1.
Okay,
May I please your lordship?
when do you want it?
After vacation.
After vacation.
Okay. Mr. B. Kaushik, learned counsel for the secondary education department, submits that he has filed the affidavit. And the matter may be taken up after the ensuing vacation. Stop, Ms. P. Das,
P. Das, your lordship.
learned counsel for the petitioners also agreed to the prayer. In view of above, list this matter. 19-1.
All right.
I deeply obligation.
My lord, item 4 and 5 may be passed over for the time being, my lord.
4, 5, pass over.
Item 6.
May it please, Your Lordship.
Lordship, on earlier occasion, Lordship, Honorable Court directed to file affidavit, Lordship, affidavit,
Additional affidavit for what?
additional affidavit, Lordship, for Lordship, whether petitioner's name has been sent back by the Deputy Secretary, Lordship. So in paragraph 8, Lordship. That has been annexed, Lordship. In additional affidavit, Lordship, page
Just-
number 43, Lordship.
Just a minute. Page number?
43, Lordship. Additional affidavit. In additional.
The order date is 7/2 or 27/2?
Lordship.
Date of the order. Page 43.
Page 43. Exactly similarly situated person, Lordship, has got order, Lordship, in this honorable court, Lordship. May I proceed, Lordship?
No. Can you hear what I'm saying? In the order of this court,
Lordship.
I had mentioned the order dated 7/2/2007
Lordship.
by the Deputy Secretary. You have annexed an order which is
Lordship.
dated 27/2/2007.
27/2/2007, Lordship.
So the correct order is 27. Correct date is 27.
Lordship, 27, Lordship. Correct date is 27, Lordship.
Then why did we mention is that 7
Lordship,
February?
I'm extremely sorry, Lordship, typographical mistake, Lordship.
Page 29. Come to page 29. The third paragraph,
Lordship. 29,
29, third paragraph,
Lordship.
the second line, the third paragraph. Department-wide order dated 7/2/2007. Return the proposal. There is some correction by correcting flute.
Lordship. Lordship, Department had order dated 7, return the proposal, Lordship.
That's why
Actually,
I have recorded
that's
7/2.
the Lordship.
Now today you are producing 27/2.
27/2, Lordship. Exactly 27/2, Lordship.
The date should be 27/2.
2, Lordship.
Okay.
Lordship, may I
Wha-
pass it the
Yes, what is
And-
that similar order?
exactly similar to speed, Lordship.
What was the order passed?
Lordship, matter has been disposed of, asked to consider the case, Lordship.
Why was it rejected, your case?
Lordship, on last occasion, Lordship, shortage of vacancy, Lordship.
Where is that?
Lordship. Lordship, in page number 36, Lordship, serial number 6, Lordship. May I read, Lordship? Page number 36.
Serial number 6.
6, Lordship.
Read.
Application is rejected due to shortage of vacancy as per principle of so and so, Lordship.
Then what will happen now if there's no vacancy?
Lordship,
What will happen if there's no vacancy?
in that case, Lordship, Lordship, as per Lordship,
Now, what are you passing on one by one? Tell me. Tell
Lordship,
me.
Lordship, in if sufficient vacancies are not available in Lordship in such
One department, you can go for other department.
other
That one.
Lordship.
Now, what about this compassionate appointment? This has been stopped, isn't it now?
That's one.
So how do we keep on directing that you consider when the compassionate appointment is being stopped?
Lordship, after 17 Lordship, that has been stopped, Lordship.
Hmm?
After 17,
17 means-
2017 Lordship, new notification has been come up, Lordship. After that, Lordship, compassion appointment has been stopped.
Let's stop. Now, what is your case?
My case, Lordship,
How do you say that your case should be considered?
before 17 Lordship.
You are before 2017.
Lordship.
Application before 2017 or
Lordship.
the government
Lordship,
employee expired?
application also, so has 17 also, and died also, Lordship.
When?
Lordship, on earlier occasion, Lordship.
Long time back, you come,
2004, Lordship, long back, Lordship.
2010, you came with a writ petition.
Lordship. And
And 2025, again, you're coming again with another writ petition. Yes, who is appearing for the state? and, yeah,
Apparently,
department?
petitioner's father, he
Ah.
died in 1999. But this
1999.
scheme which is for died in harness. All
Yes.
these years,
Scheme?
this scheme is for died in harness. Since 1999, they have survived. And more importantly, he has made his application on 2004. Though मतलब in the under the rules, मतलब within a period of 1 year, he need to make an application for compensation. Even though मतलब there was a direction from this honorable court, a consideration has already been given where it has been found that there was no vacancy, and vacancy has to be in 1999. Because his application, my lord, to kindly see, he has filed his application on 2004.
No, understood. See, where's the order of the court? Ten four 2012.
My lord.
Delay is also on your part. Immediately you should have considered, there's no vacancy, finish.
His application itself was not maintainable, my lord, because it was
No,
filed after 1 year. His case is that he at that point of time he was not eligible.
Mr. Kaushik, can you say that now? In the light of this order passed by this court?
But this order was
You have,
with a direction.
this order remains.
Yes, this order was with a direction to consider his case, and consideration has been given. So that direction has been complied with.
No, consideration has been given, but it's not given in toto. There's a provision saying that if vacancy is not available in Department A, you can go for Department B, C, D.
This order, your lordship will find at 10/4/2012,
Page.
page 28.
Yes, I've seen that.
And in fact, my lord,
You come to page 30.
yes, I've seen, my lord, the direction was to give a consideration by the district level scrutiny committee. District
Correct.
level committee.
Correct.
To place the case of the petitioner before the next meeting of the district level for consideration of appointment on compensation ground, strictly in terms of the scheme founded by the government of Assam and also in terms of the direction in the aforesaid case. Such consideration shall be made by the district level committee in its meeting.
See, application was filed. The
Madam.
more than 2 years lapsed, so they say that no consideration. He came to the court. Court said that no, you consider the case. By
In fact,
taking,
in the earlier round of litigation,
by
there was
taking,
no adjudication as to merit that whether he deserves a consideration or not. If your lordship will kindly see page 29, the third paragraph. He praised for direction to be considered by the district level committee pursuant to the scheme formulated by the government of Assam as well as in terms of the decision in Ashut Ranjan Das reported in 2006 for GLT 674 as well as the case of Poison Nessa versus State of Assam reported in so and so. It has been submitted by the stand taken by the respondent in affidavit filed by non-consideration of for appointment that more than 2 years have elapsed from the date of filing of the application is not tenable in view of the judgment order passed by the so and so as well as so and so by which it was directed that one-time measure all pending cases are required to be considered.
now you come straight to page 30.
Yes.
First line, it talks about Ajit Pator's case. Ajit Pator's case probably was that irrespective of pendency for more than 1 year, consideration should be done.
But in fact, if the in terms of the judgment of Ashut Ranjan Das and Fazlun Nessa, the scheme was formulated that after the death of the predecessor, the employee, he need to make an application within a period of 1 year. And it's an admitted case of the petitioner that he has made this application in 2004. The father died on to 1999.
Again, you're going back in time. Let us confine ourselves to this order. 10/4/2012, rightly or wrongly, court said that you consider his case. Ultimately, consideration came. That was in the DLC of 29/11/2024, saying that there is no vacancy.
And ground of rejection, lordship, shortage of vacancy, lordship, not less of time, lordship.
What is that provision you were trying to show me?
Lordship,
Any other department?
lordship.
Which part? If sufficient vacancies are not available. This is a part of which OM?
Lordship,
2015.
2015.
Right, second.
Mr. Kaushik,
Madam.
anything else you want to submit? Okay, we'll dispose it off. Please write down. Part Mr.
Yes, sir, man.
A. Sharma, Landed Counsel for the petitioner, who submits that in terms of the last court's order dated 1/8/2025, the petitioner has filed an additional affidavit incorporating the communication dated 27/2/2007, by which
এখন দেবব্রত তিৱাৰীৰ ওপৰত আমি মাইকেলত কনচালটেশ্যন আছে আমি বলতে যেটা এসিএস কৈছে যে আমি কোনৰ ওপৰত ইনসিস্ট নকৰো
the case of the petitioner was
and নতুন নোটিফিকেশন পাইছে all the cases will be considered এখন চ্যালেঞ্জ হৈছিল কোৰ্টে কৈছে আমি ইন্টারপ্রেট নকৰো on the analytical value of the budget.
has to be verified. for placing the same before the, for placing his case before the DLC for consideration for compassionate appointment. Next para, the case of the petitioner is that his father, who was an employee of Neely Government MV School, died in harness on 1999. Stop, since the petitioner did not have the requisite qualification at the relevant time, he only applied for compassion appointment on 12/2/2004. Stop, the district level committee, which held its meeting on 14/6/2024, I'm sorry, 2004. I repeat, 14/6/2004. Recommended the name of the petitioner for appointment as assistant teacher in LP school.
Principal came to the High Court. Principal.
Stop, however, the deputy secretary to the government of Assam, Elementary Education Department, sent back the proposal to the DLC. In terms of the letter dated, not in terms of, send back to the DLC. When was it sent back? How? How was it sent back?
Lordship. Lordship, that is the annexer 43, Lordship, page number. Annexer additional affidavit, Lordship. That is the deputy secretary, Lordship.
No, it did not send back to the DLC. This has been sent back to the director. Correct.
Lordship.
Then why do you write DLC then? In your synopsis,
In respect of the select opinion.
please read the last line. Send back the matter to the Director of Elementary Education on 27/2/2007 to verify the proposal in the light of the WT message sent on 26/12/2006. And then to place the matter before the DLC for consideration. What is this WT message? Any idea?
Lordship.
WT message. Page 43.
Lordship.
Why was it sent back?
Lordship, there is some qualification, Lordship, the deficit of qualification as per my instruction, Lordship. And but later on, Lordship, petitioner passed a Bachelor of Arts, Lordship, BA, Lordship.
But things are not clear, huh? Yes, that's your instruction, but WT message contain what? What is the contents of the WT message? That you not know.
WT basis. WT. It's also in the light of WT.
What did I say last? Stop. Since the matter was not placed before the DLC, the petitioner approached this court by filing WPC number 4747 of 2010, which was disposed of by order dated 10/4/2012. With a direction to the respondents to place the case of the petitioner before the next DLC for consideration in terms of the policy formulated, in terms of the scheme formulated by the state government. Stop. The case of the petitioner was not placed before the DLC for a long time. And ultimately, when it was placed, before the DLC, which held its meeting on 29/11/2024, his case was rejected due to shortage of vacancy. As per principle number 14, bracket small a of the OM dated. What is the date of the OM?
1/6/2015.
No. Is it so?
2015. Principle 10.
1/6/2014, 15,
18.
1/6/2015. Which support 10, 14A.
Lordship will take note of clause 3 also, when clause 3 of that so same one.
Where is A? Okay, 14A. 14A. Hmm.
No, when this was.
So the learned counsel for the petitioner submits that. Under such circumstance, the DLC ought to have applied, should have adopted the conditions provided under clause 15 of the OM dated 1/6/2015, which is to the effect that if sufficient vacancies are not available in any particular office to accommodate the persons in the waiting list for compassion appointment, it would be open to the administrative department, public office, to take up the matter with other departments, public offices, to provide early appointment on compassionate grounds.
Look, clause 3, my lord, I'm relying on clause 3 of the same way.
Clause 3.
Clause 3.
What does it say?
Every eligible dependent seeking an appointment under this OM shall make an application for appointment on compassionate grounds in the prescribed form with all enclosures within 1 year from the date of death of or acceptance of retirement of the employee with consent letter of the retired employee.
Okay. Next para at this stage, Mr. B. Kaushik, learned standing counsel. Elementary education submits that the application filed by the petitioner is only belated and it is in clear violation of clause 3 of the OM dated 1/6/2015, since it was not filed within 1 year. From the date of death of the employee concerned. Now, it may, however, be seen that this petitioner had earlier approached this court by filing WPC number 4747 of 2010. And the writ petition was not dismissed on the ground of delay in filing the application for compassionate appointment. And in fact, a direction was given for considering this case. Despite lapse of 2 years time. Despite lapse of 2 years. From the date of filing the application. So under the circumstances, this court is not inclined to dismiss the writ petition on the ground of delayed filing of the application when the earlier writ petition had already been entertained by this court. In that view of the matter, writ petition is disposed of with the direction to the respondent authorities to place the case of the petitioner once more before the DLC in its next sitting for consideration. And the DLC shall take into account the clause 15 of the OM dated 1/6/2015 while considering the issue of the petitioner. With the above observation and direction, the petition stands disposed of.
Public. Deeply.
That was item number 6, okay.
Last.
May I please, your lordship?
Yes,
My lord's order. This is operative part. Now, this is a matter where, my lord, some, my lord, payments, my lord, the scale was to be given to the tutor, my lord, rate for employees, my lord. My lord, lordship had passed an order, my lord, to, my lord, on submission of representations, my lord, their cases will be considered, my lord, within the period of, my lord.
okay. How many respondents are there?
My lord, respondents, my lord. 2, my lord.
Heard, Mr.
M. Dattaman.
Your name is
M. Dattaman.
in the cost list. Hazrat Mirza Ali.
He's, yeah, my lord.
You're with, he's with you. Heard Mr. M. Datta, learned counsel for the petitioner, who submits that the order dated 24/9/2025 passed by this court in WPC number
56292, my lord. Page 17, my lord.
how many petitioners were there?
My lord, number of them, my lord, that's in fact,
50 of the 49 of them.
not all have come before lordship, my lord.
orders passed by this court, by order dated so and so in WPC number 5692 of 2025 has not been complied with by the respondents despite a copy of the order having been furnished to them. So he submits that the instant petitioners are some of the petitioners in the said writ petition. Next para, in view of above, issue notice, returnable by 4 weeks, steps within 3 days.
Milord 5 also, Milord, similar, Milord. That is WPC number is 5697 only 25, Milord.
Which one? Which one?
Milord, 569725, Milord, is a odd, Milord, writ petition number.
5697.
97, Milord. Oblique 25.
Okay. So, that one line I've given you, na? He submits that the instant writ petitioners are where the petitioners, right like this. The instant writ petitioners, where the instant petitioners, where the writ petitioners in WPC number 5697 of 2025.
The order is on the same date, man. The order was passed on the same day.
Okay, in view of above, so and so.
24/9, man.
And this one? Next one?
That's one, next one, man. There's the next one I'm talking about.
Same.
Same, man.
Now, case number?
That is one, I was talking about the next case, Milord, 5697, Milord.
Oh, not in the earlier case. Okay.
Earlier case, fine, Milord. Earlier case, that order. This is 5697.
Okay, earlier case, their numbers are here and there.
Like only the case numbers are different, Milord. Otherwise, Milord, the same date, judgment is same date, Milord. But earlier, the WPC number, Milord, was.
No, see, earlier, when you filed the writ petition, there were 49 petitioners.
Milord.
Today, there are only 17 petitioners.
Yes.
So they are petitioners in different writ petitions.
No, same writ petitions, but then, Milord.
What is the number?
Well, that is the number, Milord. In the first case, Milord, WPC number is, Milord, 5692. All of them have not come, Milord. Some of them have come, Milord. This writ petition, Milord, had about, Milord. One second. This writ petition, 49 writ petitioners, Milord. Out of that, Milord, before your lordship, Milord, 17 have come. That is item number 4. In item number
those 17 persons, are they the petitioners in 5697?
92.
Then you correct it. 5692. And currently, this one item number 5?
Item number 5, Milord, WPC number 5697.
Okay.
There are a total of, Milord.
That's okay. Item 5, same order. Only WPC will be 5697. Okay. List again after 4 weeks.
May I please, your lordship?
Yes.
Lordship, while last order, lordship, respondent side was supposed to file an affidavit, lordship.
Yes, lordship. We required some more time, lordship.
How much time?
After vacation, lordship.
What is the difficulty?
Lordship, actually, my senior also out of station.
Who's your senior?
Pranabjyoti Phukan, lordship.
Sorry?
Pranabjyoti Phukan. PJ Phukan.
PJ Phukan.
Yes, sir.
What is this? University matter?
Yes, lordship.
Lordship, it's regarding gratuity amount. According to the last speaking order, lordship.
Although an affidavit was said to be, was directed to be filed,
Yes.
but the same has not been filed. Prayers made on behalf of Mr. PJ Phukan, London Standing Council. What university? For further 2 weeks' time. No, PJ Phukan, okay. Yes. In view of above, list again after the interpretation on so and so.
Lordship, deeply obliged.
Obliged.
None appears for the petitioner when the matter is called. Same was the case when the matter was listed on 17/11/2025. The writ petition is dismissed for default.
Item 10.
May it please your lordship. Matter relates to compassionate appointment, lordship. The matter is pending before your lordship. The issue of balance service of 3 years, lordship. That was pending before the division bench, lordship. And now the division bench has decided on 12/12/2025, lordship.
How? How was it decided?
Reaffirm the learned single judgment.
What is the learned single judge's judgment?
Learned single judgment, lordship, clause 1 of the OM struck down, lordship.
Is it in your favor or against you?
Lordship,
Is it in your favor or against you?
yes. Favor, lordship,
In your favor.
yes.
So balance service is not required
Not required,
or required? Not required.
not required. Matter is pending before SLC, lordship, present petition, lordship,
What do you say?
for consideration.
But only thing that,
You produce the order of the court, division bench judgment, where is it?
15/9. But can be disposed of because he has participated in that not, in terms of the notice dated 38/2025. Yes. Annexer 5 page 43, my lord.
Okay. What is this? I've asked you for the judgment.
That's-
What are you giving me? Application?
Lordship, I have not applied the copy of judgment, lordship. Today I have applied.
Then how do we believe you? It may have been against you also.
Lordship. Matter may be taken up tomorrow, lordship. I'll provide, lordship.
What is this you're giving me?
Lordship, I have submitted the required particulars, lordship, as per notice dated 38/2025, lordship.
On the last date.
Oh, last date,
Why did you wait till the last date?
15/9, on 15/9, lordship.
Why did you wait till the last date? So what is to be done?
In terms of that representation, my lord, that letter, my lord, department will consider in accordance with law.
Yesterday, there was some other orders which you have shown.
Yes, my lord,
Chief Secretary's meeting with the senior most secretaries.
my lord.
saying that beyond this date will not consider.
Already, according to that, I notes, my lord, already 600 applicants. Probably this also is there. Maybe, I am not sure. Those who have applied within time, that all has been under consideration. So since he has participated, can be disposed of in accordance with law. That's all.
Then why did you file this writ petition? If you have already participated in the sense that you have filed your particulars, isn't it?
Because that balance.
As per notice, lordship, if I have not challenged the OM lordship, my case has not been considered, lordship. That's why I have filed this writ petition, lord.
Then what about that balance period?
Balance period, lordship, less than 3 years, lordship.
No, the question of balance period occurs in your case.
Lordship. Lordship.
You want consideration by the DLC or by the SLC?
DLC, lordship.
DLC.
Yes, lordship.
Who expired?
My father, lordship.
2013.
Yes.
He was supposed to superannuate on which year?
About 2016.
16.
Near about.
Near about. Less than 3 years.
Yes.
Page 29.
Page 29.
Seven.
Page 29.
Page number 7. Thank you, sir.
Page 29, serial number 7.
It's 30.
The relevant portion is page 30.
Please write down. Part Mr. N. Hussain. Learned counsel for the petitioner and Mr. G. Pegu. Learned government advocate for the state and Ms.
4, 5,
S. Sutia, learned standing counsel, elementary education for respondent number 4, 5 and
6 maybe.
6. Stop having regard to the nature of the grievance objected by the petitioner. The writ petition is taken up for disposal at this stage. Who expired? Your mother, not father. Mother, isn't it?
Mother, lordship.
The mother of the petitioner died in harness on 23/9/2013. And therefore, the petitioner applied for appointment on compassionate basis on 12/11/2013. This page 30 is what, SLC?
DLC, lordship.
Are you sure?
Page 29, serial number 7, lordship.
No, the beginning part.
Lordship, page 30.
The beginning of this DLC. It's page 28.
First page 28, lordship.
Yes, first page.
28.
I wanted to know the date of the DLC. You said SLC.
7/7/2023.
You said SLC. This is DLC.
Matter is pending before SLC, Lordship, for consideration.
How?
After recommendation, Lordship,
You have not been recommended.
recommendation.
Are you recommended?
Yes,
Page,
Lordship.
page 30.
29.
No, Commissioner. Page 30.
Accepted, Lordship.
It is decided to forward the proposal to the government for further necessary action.
There are two column, Lordship, accepted and rejected. My case, accepted, Lordship. Page 20,
Is it not contradictory?
Lordship.
On one hand, they say you don't have the balance service.
Yes,
On the other hand, they say forward. So how should we understand this? Rejected but accepted.
yes,
Accepted but rejected.
yes.
Like that.
Accepted.
With the IC.
Accepted.
Hmm? What did I say? Hmm. Stop. The case of the petitioner was considered by the DLC which held its meeting on 7/7/2023, wherein it was observed that the late government employee did not have balance service of 3 years when she had expired. Stop. However, the case of the petitioner was accepted to be forwarded to the government for necessary action. Stop. The learned counsel submits that despite the same, since the SLC has not considered the case of the petitioner, the petition is before this court. Stop. He submits that. So what reference should we give about that judgment of the DV?
Writ appeal number 125/2024.
125
Yes, Lordship.
of 2000
24.
disposed of on
Disposed of on 12/12.
the learned counsel submits that the subject matter in respect of balance service required in order to be considered for compassionate appointment was taken up by the division bench of this court in writ appeal number 125 of 2024. And the division bench provide judgment in order dated 12/12/2025 disposed of the writ appeal.
Reaffirm the learned single judgment, Lordship.
Reaffirming the judgment of the learned single judge that the case of persons who do not have reaffirm the decision of the learned single judge that application for compassionate appointment should not be rejected on the ground of there being lack of remaining 3 years of service left on the part of the deceased employee. To stop, the learned counsel submits that pursuant to the circular. What is the circular?
Case 43, Lord.
Circular
Yes.
issued by the, pursuant to the notice issued by the government of Assam in the personal department on
38/2025.
38/2025 5, requiring all those interested to file their particulars on or before 15/9/2025 to be considered for compassion appointment. The petitioner also has submitted her particulars on 15/9/2025. Stop. He therefore submits that the petitioner should also be given the benefit of consideration in terms of the have you annexed a common judgment? Common judgment.
Common judgment, yes, Lordship. Page 39, Lordship.
Hey, I don't know. The leading case is 342/2025. Abdul Qadir Bakshi versus Sirvatam.
Sorry, how much?
Writ petition number 342. It's in page 43 only, my lord, that notice in compliance with, so in the second line, page 43.
In terms of the common judgment rendered by this court on
3/4/2025.
3/4/2025, wherein the lead case is WPC number 342 of 2025. Next para, considering the above position and upon perusal of the materials available on record, the writ petition is disposed of with a direction to the respondent authorities to place the matter, to place the case of the petitioner before the SLC for consideration in terms of the notice that was issued on 15/9.
No, 38/2025.
I'm sorry, 38/2025. Writ petition accordingly stands disposed of.
My senior is on the.
Your senior is on legs.
Yes, Lordship.
My lord, I have challenged the provisional select list, but in the meantime, my lord, the private respondent number has already been appointed, my lord. So I think, my lord, I have to challenge their appointment letter.
Will withdraw with liberty.
Yes, my lord.
Your name?
Arafi.
On the prayer of Mr. I. Rafiq, learned counsel for the petitioner. And not objected to by Ms.
Esquire.
Esquire, learned standing counsel, Elementary Education Department. The petition stands disposed of as withdrawn with liberty to file afresh.
All right.
My lord, as per the order dated 4/12, my lord, we have approached to the authority, my lord, and which has been duly received by them, my lord. And what action they have taken, my lord? This is the application and acknowledgement. It's in my detail. So, this plan. London. Basically, case is non-issuance of, my lord, transport certificate of my small kid, my lord.
Two
So-
children.
Two children, my lord. They are covered under, my lord, Right to Education Act also, my lord.
Why is that?
Because they are not giving, my lord, they are asking for some money, my lord. I have annexed, I have given legal notice.
No,
on-
why do you want transfer from that place?
Because I have shifted already. Father
have
has
shifted.
shifted.
From Silchar,
Yes, my lord.
where?
To Badarpur,
Badarpur.
my lord.
So to get admission, you require transfer
Yes,
certificate.
yes.
And they're not giving.
Otherwise, no, we will not get,
And this school, Universal Knowledge Park School,
my lord. The private
what-
respondent number, my lord, they are not issuing certificate. They
what
are,
kind of school is this?
the school is a, my lord, a private school, my lord,
Private school.
private school.
So you're challenging
Challenging, my lord, not non-issuance
non-issuance
of
of
transport certificate,
TC by the private school.
my lord.
Now, what is the role of the others? You are for the private school.
Private school.
Why are you not issuing?
My lord, firstly, my lord, this repetition is not maintainable because, my lord, this is the private school, my lord. His prayer, my lord.
Leaving
kindly
that
see-
aside, why are you not issuing the
No,
transfer
I am
certificate?
issuing, my lord.
To the-
Kindly see
with the-
page number 25, my lord. Kindly see, my lord, for a moment, my lord.
Read petition.
Page number 22, my lord. I have
When-
issue notice to him, my lord, to appear, my lord. Some documents is required. He has
Twen-
not given,
22 of read petition.
my lord. 25, my lord. I have already given him
25.
25, my lord.
Okay. Let us see.
Page number 25, serial number 3, my lord.
Serial number 3.
But,
Yes.
stop, my lord.
Read.
That despite repeated requests by the school authorities, you failed and neglected to provide the required documents and to complete the formalities necessary for issuance of TC, my lord.
What documents, my lord?
My lord,
I'm getting
They
my,
have to give, my lord, they have to give the fees, fee receipt, and admission receipt, because 2005, his kids has not admitted in the school, my lord. He sought for,
See, whatever it may be, why don't you mention that clearly? These are the documents A, B, C, D you have to give. Simply saying required documents.
I have asked him to appear, my lord, again and again, my lord, again.
Where is that? Where is the thing that you have asked them to appear?
it is a mere notice reply, my lord, against my notice.
And another notice was also given, my lord, page number 20, my lord.
This is addressed to whom? Petitioner,
Uh,
page 20.
Page 20, my lord.
Hmm.
The school authority has given letter to him to appear and some
Let him
formality-
show, my lord, original record that it has been given to me.
See, you're interested only in the transfer.
My lord, I
certificate.
don't want to go for dispute, my lord, my children.
Correct. You are also you are also not objecting to issuance
No,
of
no, we
transfer
are not objecting,
certificate,
my lord. We are not,
subject to you receiving the requisite
my lord,
receipts and all whatnot.
my lord.
Receipt is with them, my lord, in the school.
So you do one thing, you give one more letter. That this is the requirement.
My lord, my lord,
Accordingly, you give the requirement. We'll close it.
my lord, my lord.
Lordship, one more thing, my lord, is apart, my lord. On the last occasion, my lord, the inspector school of higher secondary was directed to submit instruction, my lord, last order, my lord. I have accordingly, in compliance with the order of 412, my lord, I have approached to the inspector of school, my lord. He said, my lord, the school does not have required permission also, no recognition, nothing. They are,
Then what will you do with the TC then?
my lord, TC has to give, my lord, otherwise how I'll make my children admitted? That will take legal recourse to
The
that.
school where you are going to seek admission. What they will do with the TC when the school is not recognized?
My lord, as per the instruction, my lord, instruction submitted by the government, not by me, my lord.
It will not be on your benefit.
Lordship will see the order dated 412, my lord.
If the
What
school in Badarpur come to know that this school is not
school is in
recognized,
Silchar, I am in Badarpur,
that's what you want to admit your children in Badarpur.
Badarpur, my lord.
If the school in Badarpur where you are seeking admission come to know that you are coming from a school which is not recognized, then
Then we'll take, my lord, appropriate action in that case, my lord. But for this, my lord, I cannot play up my children's life, my lord. For the sake of a small amount or whatsoever, my lord, under what authority, my lord, they are asking money?
you're asking money.
Yes,
No, my lord, I have not asking them.
Where is the
money, my lord.
statement?
No, no.
I made, my lord, categorical statement, my lord, in the annex also document.
Anyway, we'll not go into all these things, okay?
My lord.
This is the welfare of the children involved, you
Yes, yes,
see.
my lord. Let him
So
take, my lord,
let them
instruction.
give a letter to you in clearly indicating what are the requirements. All right. And accordingly, you submit the requirements and they will give the TC.
My lord.
Matter ends like that.
My lord, another thing, my lord, as per the last order, my lord, inspector of school has to do something, my lord.
What?
Lordship, I have given as per the last order, my lord. Last order, kindly, lordship, kindly have a look, and I have applied also, my lord. 412. Standing council has to file some instruction. I see. On my application, man. That extra what is there? Alva. Paradari paise.
Who is respondent number 4?
Respondent inspector of school. And I have given copy to him also, my lord, be duly received.
My lord, it is a non-permitted, as per my information, it is a non-permitted school, my lord. And application was duly received from the petitioner, my lord. And this will refer to the deputy commissioner by the inspector of school being a head of the district, my lord. And inspector of school has no role as because they have not taken the permission yet, my lord. This is my instruction.
Okay. Now, see, in the last order, it says that at this stage, Mr. Borvia, learned counsel for the petitioner, submits that he may be allowed to file a fresh application
Yes, I have submitted.
to the respondent number 4.
Yes, I have given, my lord.
No, for what? For what? Application
For
what?
NOC, my lord. For TC, my lord. That's are the said illegally demand due to the change of school, which is contrary to law. So and so, I do hereby advise request to kindly look into the matter and yourself observation and proper inquiry against the said school and their activity illegally demand for which the stem action against the principal and vice principal of the said school and do please issue thereof. I am asking for my
TC
TC, my lord.
before the inspector of school.
Because, my lord, I They are asking money. I have to knock the door of some authority. Authority is the inspector of school. It is the higher secondary school.
Now you're coming before this court. While you're coming before this court, you want to go before the inspector of school.
No, man. I have already given application.
So
there.
we'll ask the inspector of school to do the needful then. Why should I pass the order?
No, my lord. Why I have approached, my lord, I have given my notice also copy to the inspector of school, my lord, for redressal of my grievance, my lord. Lordship will see page 19.
So let him consider and dispose your case then. Court will not say anything.
My lord, that will not act, my lord. It will be given clean.
Then you come back to the court again. Right now, you go there.
Where to go, my lord?
You are going there, inspector of school.
I'm
responsible
not
for-
going there, my lord.
This is your application. You have gone there.
This is my application.
You have sought the permission of the court to go there
No,
also.
my lord,
Go there.
because on the last occasion, lordship, kindly see page 23, my lord.
Mr. Borbuya,
Lordship,
you should be clear what you want. You have come here before the court asking for some relief. Second day, you say that I'll go before the respondent number
no,
4.
my lord. In the court, I
With
said, my
application.
lord, they said they did
Then
not.
I'm telling you, you go there.
My lord, they are not.
Will
they
not stop you. Go there.
No, my lord, they said they did not get the receipt of my notice, my lord, which I have already given page 23, for which, my lord, I have to give, my lord. They said they did not receive my, for which I was compelled to give my.
So please don't say anything extra now. If you agree, we'll dispose it off by asking them to give you a notice or giving a letter saying that these are the requirements. You submit that and we'll ask them to give you the TC. That's all. Matter ends there.
My lord, so what
If you want to complain against the school, it's up
No,
to
my
you.
lord, I am not against the school. If it does
Go
or
ahead.
does not, that we are not concerned, man. I am concerned only with
I'll
my
tell you,
children.
the only problem is capital EGO.
Ego, maybe.
Capital EGO is the problem between the parties. That's all. Only your children.
My children. Considering the fate of my children, my lord, lordship will pass appropriate order, my lord.
Please write hard Mr. J.I. Borboya, learned counsel for the petitioner. Mr. U. Sharma, learned standing counsel, secondary education department, and Mr. F. L. Askar, learned counsel for respondent number 5. Next para, the petitioner is before this court with a grievance that the respondent number 5 has failed to issue transfer certificate to the 2 children of the petitioner who were studying in class
LKJ and class 3.
3 and plus LKG. Despite submitting application for the same. So the learned counsel for the learned counsel for the petitioner submits that transfer certificate is required because the petitioner has shifted from Silchar to Badarpur. And therefore, change of school will be required. And without having a transfer certificate, getting the admission for his children would be not possible. Next para, the learned counsel for respondent number 5, on the other hand, submits that the petitioner was asked to come to the school and
Lord,
submit
fix the date, my lord, from today.
and submit the requisite documents and particulars. But the petitioner has failed to do so. And that is why the transfer certificate could not be issued. So Mr. U. Sharma, learned counsel, submits that in terms of the last court's order, he has received instructions which is to the effect that the school has not applied for
Yes, a non-permitted school.
for
They have not.
permission to open the school.
Yes.
And therefore, the inspector of school concerned does not have any records
Any role, yes.
pertaining to the said school. To stop, the learned counsel for the respondent number 5 also submits that since the school is a private school, writ would not lie. And on this ground, the writ petition should be dismissed. Full stop. Upon considering the submissions made by the learned counsels for the parties, this court would not like to would not like to enter into the maintainability of the writ petition for the simple reason that the welfare of the two children would be affected if the litigation is dragged further. Stop. What would be required at this stage would be for the petitioner to fulfill the requisite to be deposited or submitted before the school authorities, and the school authorities accordingly should act upon it and issue the transfer certificate to the children of the petitioners, to the petitioner, children of the petitioner. Next para, in view of above, the respondent number 5 shall issue a letter to the petitioner clearly specifying what are the documents and particulars that would be necessary to be submitted to the school in order to provide the transfer certificate of the two children of the petitioner. The same should be furnished to the petitioner within
my lord, 4-5 days, my lord, because session will start, my.
10 days. ma'am.
within 10 days from today. So upon receipt of the said certificate, the letter, the petitioner shall ensure submitting all the requisites as mentioned in the said letter. And upon receipt of the same, the school authorities would issue the transfer certificate without delay. The entire process be completed within a period of 15 days, 2 weeks from today.
My lord, they have to issue letter in my present address of the writ petition mentioned in the writ petition.
Where's that address?
My lord, cost title it is there, page 4. Bilal Hussain so and so, son of Altaf Hussain, village, Kadiman,
That will take some time. Why don't you go to the school and collect the letter?
The moment I go, my lord, I was been humiliated several occasions.
No, in order to collect the letter. Otherwise, if it goes by post, it will take time.
It will be 1 day, my lord, speed post from here to Jorabad, my lord. 1 day it will take. Let them send by speed post.
Silchar to Karimganj, my lord, 2 districts.
No, your address is Badarpur.
Yes, yes.
Badarpur Ghat. How long will it take?
45 minutes, my lord, from.
No, by post.
By post 1 day.
2-3 days, my lord, even speed post, my lord.
72 hours is the outstay northeast, my lord.
So the entire process should be completed within a period of, you make it 3 weeks
From today.
from today. The respondent number 7 school shall communicate to the petitioner in the address given in the cost title of the writ petition.
By speed post.
You can send special messenger also.
Written stands disposed of, my lord.
Writ petition accordingly stands disposed of. Please settle it. Don't take your.
Yes, yes, my lord, I am not. What is the matter? Children, nobody plays the life, my lord. They are thinking they are the king of Barak Valley. That is the way.
Right.
Your lordship, in this matter, instruction is awaited, your lordship.
You need some more time.
But
Family pension.
family pension pending before the director of pension, my lord, respondent number 5, my lord. That's why in the earlier occasion, my lord, this honorable court directed to receive instruction, my lord.
You are for the director of pensions.
Yes, your lordship. We'll file affidavit, your lordship. Instruction is ready. They will send your lordship. I'll file affidavit, your lordship.
Okay, Miss
K. Fukan.
K. Fukan, learned government advocate,
2 and 5, your lordship.
appearing correspondent 2 and 5. Praise for and is granted further 2 weeks time to receive instructions and to file affidavit. List again after the winter vacation on so and so.
Oblige, your lordship.
Oblige.
12 more. Okay. Time is up. Yes.
Made, please, Your Lordship. My lord, petitioner before your lordship was working as a professor of IIT Physics Department, my lord. And during the service period, my lord, one, my lord, complaint was lodged by the one of the scholar, PhD scholar, my lord. And ultimately, that complaint was, my lord, constitute a committee, that is, my lord, internal complaint committee, my lord. And internal complaint committee passed a report, my lord. And thereafter, he has replied by objecting the constitution of the debt complaint committee, not as per rules. And thereafter, my lord, after sitting over the 4 months, my lord, respondent authority issued a so cause memorandum of search, and ultimately, my lord, penalty of, my lord, compulsory retirement is given. And thereafter, he filed a my lord, appeal before the President of India. Till today, my lord, that complaint, my lord, appeal is pending, my lord. I came before this honorable court that challenging the internal complaint committee as well as entire proceedings, my lord. My lord, search memorandum of search as well as the report as well as the penalty. My first submission is that internal complaint committee is not under the rules, my lord, sexual harassment and women workplace, my lord, section 4. My lord, they did not, my lord, formation of the committee. Section, my lord, 4C, my lord. And 4C, my lord, one member from among the non-government organization or association. And that reply was, by objection was raised. And that is under record. And thereafter, my lord, regarding the departmental proceeding is concerned, my lord, parallel proceedings cannot be allowed by this Honorable Supreme Court, my lord. That's why I came before the Honorable Court to challenging both, my lord, internal complaint committee, constitution of the internal complaint committee.
Posh Act. So under Posh Act, which one?
My lord, section 4C, my lord.
4C.
My lord, constitution of the internal complaint committee, C, my lord. 2C.
2C.
Oh, one member from among the non-government organization or association committed to the cause of women or a person familiar with the issue relating to sexual harassment. Section 4. 4C, my lord.
4-2C.
My lord. 4-2C. And my lord, thereafter, my lord, after giving the report, submitting the report, without any action on the basis of that report, they, my lord, after 4 months, they parallelly, my lord, they issued a show cause. That show cause is illegal by my lord, at this stage, I am, my lord, your lordship, go to the Honorable Apex Court judgment, my lord. For the purpose of notice, my lord, business only, my lord, I am going to.
What is the judgment?
Judgment, my lord.
Parallel proceeding.
Yes, my lord.
Parallel proceeding.
Parallel proceeding, my lord.
One is under the Posh Act and
Yeah.
one is under departmentally.
My lord, para, my lord. Para 44 and 41. No. Sorry.
So under the internal complaints committee.
Yes, my lord.
Under the internal complaints committee, what action was taken against you?
No, any action was taken.
So then they've taken action under the department.
No, that cannot, my lord. So
why not?
Says that your lordship go through it, my lord. Para 44, my lord.
No, they cannot penalize you twice.
Yes, well, you cannot be treated as a preliminary inquiry. That internal committee report, my lord.
That was treated as a,
Preliminary, because no action has been taken. Parallelly, they issued a show cause, my lord. It cannot done, my lord. Your lordship go to it. my
no,
lord.
where is that document? Just show me that document first. In your writ petition,
Yes, my lord.
where is the outcome or report of the Internal Compliance Committee?
Yes, my lord. In the reportive para, my lord, page, my lord. Page 68, my lord.
68. Where's the conclusion?
Page 82, my lord. My lord, page 81, my lord, recommendations, my lord. Page 81. Your lordship.
Yes, yes.
The internal committee recommends the punitive action against the respondent based on the status of the institute, section 15.91. This censure is conform to the requirement states in the Sexual Harassment of Women at the Workplace Act 2013, whereby punishment may be in accordance with the service rules of the institutes. Additionally, as noticed in Sexual Harassment of the Women at Workplace Act 2013, section 15B, committee also recommending the compensation to the complainant, which may also considered as a measure of censure. Professor Pauls also should be debarred from the taking any female student staff during his full tenure of so-and-so. The includes of the female student staff enrolled the PhD project staff, research assistant, meta so-and-so. Professor Pauls should not be committee member of the any female students committee of the listed in point 1. The includes currently students of so-and-so. The female so-and-so teacher should be initiated department level of care so-and-so under the so-and-so not willing to send so-and-so. Undertaking should be taken so-and-so. Institute will not nominated him to so-and-so. Accordingly, Sexual Harassment so-and-so Act, Professor Pauls will be required to be compensated the complainant for mental trauma, pain, sufferings, distress caused to the aggrieved woman. Appropriate compensation will be 6 months fellowships, which is approximately 1,80,000. Also, Paul should not be given any administrative responsibility in the department or institute level during the full tenure. Further, he should be removed from the existing committee with immediate effect. The institute should be request Professor Paul who give written apology for being involved in action leading to a hostile work environment, and he should also be requested to provide the undertakings agreed by the condition as a measure of the prohibition of the future requiring this incident inside the office space. Internal committee urge the head of the institution revisit the office order so-and-so, which instruct the doors may be bolted, that a new order may be circulated stating that apart from not bolting the door so-and-so, mandatory 6 and consent and female so-and-so, according to the section 31 so-and-so act shall be provide report findings of the emperor, which is case director so-and-so, copies report may be available.
Okay.
And thereafter, my lord, I file a reply, my lord, Annex 5 of section regarding section 4.
This
page
is, this is,
85.
just a minute. Listen to me also.
Oh, my lord.
This is the recommendation.
My lord.
Correct. Now, after this recommendation, what is to be done?
Nothing, my lord.
No.
I file a reply of this inquiry report objection.
This recommendation report is given to you, correct?
Yes.
Has it been implemented?
No, nothing. They are
What is the procedure otherwise?
procedure, my lord, after getting this report and thereafter after reply, my lord, they have to punish me or any action has to be taken because of this is the main inquiry. It cannot be treated as a preliminary inquiry, my lord.
Okay, so this
I am objected this constitutor of the committee because of that, my lord, your lordship base.
I'm asking you something, you're going in your own flow.
My lord.
Please give some attention to
Yes,
the side
yes,
also.
yes, my lord. And as per my instruction, after receiving the report,
Just a minute.
My lord.
So Internal Complaints Committee was formed, then they had certain findings and ultimately recommendation.
Recommendation.
And copy was given to you.
Yes, my lord.
Thereafter, no action taken under
No
this.
action taken after 4 months.
And this recommendation was treated as a preliminary inquiry
They may be treated as a preliminary.
and departmental proceeding was drawn against you.
Thereafter, after 4 months, they, without any action, the departmental proceeding was initiated.
Should I kindly present
My-
the Act section 13
My,
of that act, Visakha Act, Lord.
I'm just trying to gather the facts.
My lord,
Okay. What the rule says, what the law says will come. to
my
that
lord, my
later
lord,
on.
I'm going to one by one.
Take your own time.
Yes, my lord,
So complaint was there, committee formed,
my lord.
then they made, they came to a finding,
My lord,
they made certain recommendations.
my lord.
Now, copy was given to you. But did you file a reply to this?
Yes, reply.
Then after you file the reply,
Reply, I am challenging the constitution of the committee because that was not complied with regarding my,
in the reply,
yes, my lord.
during the constitution, you were not given a copy. When the internal complaints committee had,
First were not received, my lord. Because of that, first they give the my lord,
no, there should have
opportunity
been a notice.
notice,
earlier.
my lord.
There should have been a notice saying that this is the internal complaints committee. This is the allegation against you. What do you have to say?
Yes, my lord.
Correct?
Yes, my lord.
That time you could have raised that objection. Composition is not correct or something like that.
No, no, I am, my lord, after getting the report. I am objected on the orally, but they did not give any opportunity also. That facts was also there, my lord. I am not on that is the notice stage. And thereafter, my lord, I strongly, my lord, objected that the committee was not follow the sections 4. Because of that 4(2)(c).
That objection came after the recommendation,
Yes, my lord.
not before that.
No, before that, my lord, they,
Before that, you did not get the opportunity to object.
yes, my lord, not only that, they have also not given in their cross-examination also. That was is there, my lord. I am not on it now, my lord. My contention is that, my lord, this report is to be treated as a final inquiry.
Okay,
And, my lord,
then where is the document about the departmental inquiry?
departmental inquiry memo of charges page 100, my lord,
100.
my lord.
When was this given to you?
It was
Dated?
3/11/2022.
Memorandum.
My lord.
And this
My
report
lord,
was,
that report was submitted on 11/4/2022 and 3/11.
sorry,
My lord, report was submitted on 11/4/2022
correct,
and memorandum of charge was submitted on
311.
3/11, my lord. And now I am contention is that entire proceeding under Rule 14 is illegal, my lord. Because of the Honorable Apex Court is clearly stated in this judgment, my lord.
Page 100 is the memorandum.
Yes.
Then,
Then, my lord, inquiry officer was appointed, presenting officer was appointed, and I was all, my lord, objection was given, as well as the all doing, and ultimately is penalty imposed, page 185, my lord.
185.
185 and except 12. Which is challenged before lordship. Whereas Professor Paul Sports, professor attached to the Department of Physics was issued a second so-called Bide memo number so-and-so, and whereas careful consideration of the reply dated so-and-so, Professor Paul's to be above memo, and after giving personal hearing to him, the competent authority has imposed following penalty under Statute 15(9) pass the following compulsory retirement, Professor Paul's with effect. And thereafter, my lord, I file, my lord, appeal before the Honorable Visitor in Indian Institute of Technology and Honorable President of India. That now is pending, my lord, till today. My lord, my contention is that if I'm going to the Honorable Apex Court, I lordship, my lord, your lordship, judgment 2013 1 SCC, page 297, my lord. Para 44, my lord. May I read, my lord?
yes,
In what we have discussed above, we are of the considered view that guidelines in Visakha should not remain symbolic, and following further directions are necessary until legislative enactment on the subject is in place. The state of union territories which have not yet carried out adequate and appropriate amendments in their respective civil services conduct rules by whatever names these rules are called, shall do not within 2 months from today by providing that the report of the complaints committee shall be deemed to be an inquiry report in a disciplinary action under such civil service conduct rules. In other words, the disciplinary authority shall treat the report, finding, etc. of the complaint committee as the findings in a disciplinary inquiry against the delinquent employee and shall act on such report accordingly. The findings and the report of the complaint committee shall not be treated as a mere preliminary investigation or inquiry leading to a disciplinary action, but shall be treated as a finding report in an inquiry into the misconduct of the delinquent. My humble submission is that, my lord, that second, my lord, inquiry conducted by the under Rule 14 cannot, because of that already a internal complaint committee was made and thereafter the report was submitted, my lord. That should be treated as a, my lord, inquiry, my lord. So my humble submission is that, my lord, at this stage, notice may be issued and file it, my lord.
See,
my lord.
paragraph 44.1.
Yes, my lord.
Amendment is required. Amendment has been done.
Yes.
Conduct rules.
Yes. New act.
What does it say?
Can I want to 14th to proviso, my lord. I only want copy, my lord. I'm sorry for that.
14.
14 to proviso, my lord. My lordship.
CCS, CCA.
My lord.
This is for the central.
My lord.
Yes, you were saying something?
Firstly, this matter is pending before the visitor in appeal. They have already reacted to this appeal and acknowledged. And the pairwise comments are being, instructions are being called from the ministry. So that while that appeal is pending before the President of India, the visitor, Lordship, may simply, Lordship, that we should notice and wait for the result of that appeal. That is likely to be, because IIT has been informed that appeal has been pending by ministry has been called.
All right,
for
we'll
the
issue
next-
notice only at this stage.
I am not praying today any interim order.
There cannot be any
That
interim order
appeal
at
was
this-
filed on, my lord, 30/11/2024.
But now they take this.
And reminder also, so we cannot wait till, my lord, because of
No,
that.
correct.
My lord.
But the impugn orders also passed in October last year.
Lordship.
So at this stage, there's no question of stay and all that.
Yes, I am not praying today.
Heard Mr. N. Bora, learned counsel for the petitioner, who submits that by filing this writ petition, the petitioner has challenged the impugn order issued in the form of memo, inverted comma, memo, dated 5/10/2024, bracket index at 12, by which he has been compulsorily retired from service with effect from the afternoon of 5/10/2024 from the post of Professor in Department of Physics in Indian Institute of Technology, Guwahati. He submits that the impugn order has been passed on the basis of a departmental proceeding drawn against him, which was preceded by an internal complaints committee which had made a recommendation for imposition of certain penalty upon the petitioner. Stop. He submits that taking the same as a preliminary inquiry report, comma, a department proceeding has been drawn, which is not permissible in law. In terms of the decision of the apex court in Medha, Kotwal, Lele and others versus Union of India and others, report in 2013, 1 SCC 297. Next para, the learned counsel further submits that the petitioner had also filed an appeal before the Honorable President of India, who is the visitor of the institute, on date
My lord, 30/11/2024, my lord.
From where you're saying that?
My lord, your lordship go to it, my lord, next
86.
one.
Date is not there, no?
Date is not there, but there is a, my lord, page 207, my lord. 207. This is a consignment, my lord, postal consignment, was it, there's a dated 3/11/2024, my lord. First, my lord, counter number so 30/11/2024.
Which was sent by the petitioner.
Petitioner, my lord, by postal, my lord.
No, I'm
And
repeating.
reminder also given, my lord, page next. This is the consignment about next 208, my
Mr.
lord.
Bora, I'm dictating.
Oh, I'm sorry for that.
Which was sent
Sorry.
by the petitioner to the appellant, to the authority concerned on 30/11/2024 by, this is what, speed post?
Speed post.
Speed post. Stop, despite the same, since there has not been any response from the appellate authority, the petitioner, having no alternative, has filed the instant writ petition. In view of above, issue notice of motion, returnable by 4 weeks. Mr.
I am for one.
For Union of India, lordships.
Mr. Chakraborty. Your initial, please.
B.
Mr. B. Chakraborty. Learned, you are the CGC. Learned CGC accepts notice on behalf of respondent number 1. Well,
225 plus. 225. Respond number 225, IAT, lordship.
You are senior counsel.
I'm, your lordship.
What's his name?
S. Sutradhar.
Mr. S. Sutradhar, learned counsel, accepts notice on behalf of respondent numbers
225.
2 to 5. Notice is therefore complete. Petitioner to furnish requisite copies of the writ petition to the learned counsel appearing for respondents within 2 days. Mr.
RP Kakoti, lordship.
Mr. RP Kakoti, learned senior counsel, appearing for the IIT, submits that there has been some feedback from the appellate authority since some queries were made. And therefore, pending a final decision by the appellate authority, court may await the decision to be taken. The state submission made is taken note of. List again after 4 weeks.
Or well, interim order will consider next returnable date. That
What is the interim order?
my lord going to stay because I have no any job, my lord.
No, you want to go back.
My lord.
You have already gone out last year.
But at least interim order next returnable date. But after that may be observation. maybe.
No, issue notice on the interim prayer as well, returnable by 4 weeks.
Fix it that, my lord.
List again on so and so. Give a date.
March.
You take a book.
Oblige, your lordship.
Give this inside.
His lordship. But petitioner was HOD, but some false election he was released from. Then he approached this Honorable High Court, has interfered, my lord, and says that as per GU, what university report, he has not done this. Then he wanted his reinstatement, my lord, and that was not done. He filed another writ petition, my lord. And last occasion, my lord, this writ petition, my lord, disposed of page 85, 84, my lord, that there is direction is given, my lord, D1 82, my lord. Relevant is 84. That you have to, direction is given the petitioner to file a representation along with the writ petitioner before the principal, my lord, and it should be disposed of the speaking order, my lord. Now 86 is the speaking order that says that when your turn will come, then will reinstate. He in a different way, my lord. That was that. So why, that is why the impugned speaking order is 86. When,
What is the name of the college?
my lord, Guwahati College, my lord.
Guwahati College.
So Article 21, my lord, when he was released in front of everybody without any department proceeding, and that also proved false, he has some, my lord, prestige. That is why he approached this, challenging this impugnment. It says that when your turn come, now next immediate assistant professor will be given. But he was term is without completion of his term, by some false allegation he was removed. That is why there's grievance, my lord.
Petitioner is what? Head of department?
Yes, my
Botany.
Botany, my lord. That allegation is,
What is the action taken against you?
my lord, he is
What is the
released
allegation?
from- yes, that allegation was proved false, my lord, by Guwahati University, my lord, page 84, my lord.
Some remark was given.
Remarks was given and released from this. So remarks was expunged, my lord. Kindly see page 84.
After that, what happened?
Then he find a representation that since nothing is there,
Hmm.
I am released. My prestige is lowered. So let me join to rest of my time period. But that was not considered. He again
Join as what?
HOD.
You were relieved from HOD.
Yes, some false allegation.
Some
That-
allegation was there.
Yes, two
And
allegations.
some adverse remark was given.
Yes, yes.
Then
Both.
you were relieved from your HOD post.
Immediately we approached, then this honorable court has said, based on the report of Guwahati University, that nothing such allegation is not proved, nothing such allegation is there, because allegation is that there were some students from appearing examinations and some marks was not uploaded, but university says that no, every student was allowed and marks was also uploaded, so it's false proof. That is why this honorable court has observed that kindly see page 23, 24, my lord. Other first writ petitions order, my lord. Page 27 and 29, my lord, kindly see. Para 11, para 7, 11, my lord. Page 27.
It's okay. What is the speaking order?
Impugned order says that there is a rotation system. When your turn will come, then we'll consider.
Where? Which paragraph?
My lord, page 86, my lord.
Paragraph?
Paragraph, my lord, middle, just 3 paragraph from bottom, my lord. When the 3 years term of the
HOD.
present HOD, Dr. Umar Chowra is completed. That is completed, man, already. The next eligible assistant professor will be.
Who is the next
Professor in the
eligible?
department, yes, my lord.
Who is the next eligible?
My lord, eligible.
Who will be the next eligible professor?
My lord, someone other, my lord. He, not the petitioner. Petitioner will come after 4 years or 5 years, 6 years. But his grievance is that when midway his term, he was removed, and that is false proof, expunged, then he should allow to complete his tenure. Otherwise, stigma is gone, my lord. It's
The
because
present HOD term will expire when?
I think, my lord, 3 years term, if we calculate 28/11/2022, it already expired, my lord, 28/11/2000.
When did he start? holding the post.
28/11/2022, when he was released. And from 3 years already extended, now some other will be given, my lord.
All right, we'll issue notice heard, Mr. M.J. Barwa, learned counsel for the petitioner, who submits that this is the second time the petition is before this court.
Third time, my lord.
Third time?
First challenge, second, my lord.
I'm
because-
sorry, yes, third time.
Yes.
He submits that the petitioner is the head of Department of Botany
Yes.
Department
Guwahati College.
in Guwahati College at the relevant time. And on account of certain allegation, some adverse entry was made in his service book, due to which he was relieved from the post of the.
He was released first, then service book is, so 28/11/2022, he was released immediately, then service books also accordingly. So 28/11/22, he was released from the HOD.
Then after that?
Then service book also adverse remark is given, my lord.
Service book written later on?
Later on, my lord.
Okay,
And
what did I say? Service book. No, service book, full stop. The rest you cut.
says so expands by this only.
I know. Service book, full stop. Before the adverse entries was made in his service book about the petition was relieved from the post of HOD Botany Department. Stop being aggrieved, the petitioner approached this court by filing WPC number 6276 of 2023. And this court, white order dated 23/10/2024, disposed of the writ petition by expunging the adverse remarks made by the principal of the Guwahati College.
Yes. Based on report of what? Page 20.
Based on the report made by the Guwahati University.
Guwahati University, yes. My lord, page 29, paragraph in the court, in view of reply made by Deputy Controller of Guwahati University, examination, Guwahati University is of the considered opinion that there is no necessity.
That's all right.
on
See,
the-
then you write,
Yes.
despite the same,
Right.
since the petitioner was not put back in the post of
Yes.
HOD Botany Department, he approached this court by filing his secondary petition, that is WPC number 1375 of 2025. So the writ petition was disposed of white order dated 12/11/2025 by directing the petitioner to submit his representation
Yes.
before the respondent number 5. That is the principal of Guwahati College. And the respondent number 5 was directed to dispose of the same by passing a speaking order within the specified time frame. So person there too, the principal of the college, bracket respondent number 5, passed an order on 19/11/2025, by which
Last page.
it was stated that the post of HOD was being held on turn basis. And the petitioner will be considered for the said post as and when his turn comes. It was also indicated that the tenure of the term would be 3 years. Stop, I agree if the petition is before this court again through the instant writ petition. Mr. M.J. Barwa, learned counsel, for the petitioner submits that the petitioner was removed from the post of HOD Botany Department in the midst of his term,
Yes.
and therefore the impugn order speaking order dated 19/11/2025 should be set aside, and the respondent number 5 directed to place the petitioner back into the post of HOD Botany Department. Stop, he also submits that the present term of the term of the present incumbent is also is due to expire shortly. Next, para in view of above, issue notice of motion returnable by 4 weeks. Mr.
S. Das.
S. Das, learned standing counsel.
I
Higher education accept notice on behalf of respondent numbers
1 and 3.
1 and 3. While Mr. R.C. Alam accept notice on behalf of respondent number 2. How many? 1, 2, 3.
4, 5, and 6, my lord, the registered notice will go on.
Petitioner to take steps for service of notice upon the respondent numbers 4, 5, and 6 within 3 days by registered post with ADD, okay? Then the extra copies be furnished to the learned counsels paying for the respondents today within 2 days. Next, matter also issue notice on the interim prayer made by the petitioner, returnable by 3-4 weeks. List again also in.
My lord, interim maybe. Till then, no.
Notice.
Notice. Oblige.
At this stage, only notice.
My pleasure lordships. In this case, my lord, petitioners are dropped the chair, my lord. Earlier, they approached this honorable court, and honorable court passed an order to place the matter before the high power committee. Then it was placed, my lord. Lordship, kindly peruse the speaking order of the director, my lord, where it is contrary to the honorable court's order.
Where is it?
Page 96, annexure 10. It is stated that we don't have any 2 years criteria and our name is not shown in the DP. Whereas I have annexed DP details particular in this case also, my lord. Earlier also we have annexed, we were annexed, my lord. 2 years criteria is already been condoned, my lord, condoned by this honorable court, which I have already annexed, my lord. Several orders, my lord, which is contrary to the honorable court's order, my lord. That is my case, my lord. Let the matter be bring instruction, my lord, regarding the speaking order, my lord. Let notice be issued and bring instruction. It is condoned by this honorable court, my lord. I have annexed two order passed by this honorable court, my lord. Last order also, which was passed on 29/10/2019. It is stated that 2 years criteria is condoned by this honorable court, my lord. That is my case.
Lord Mrs. A. David, learned counsel for the petitioners. Submits that by filing this petition, the petitioners have sought for a direction to the respondent authorities to regularize their services, which otherwise has been denied to them wrongly. In terms of the communication date of 16/7/2024. issue notice of motion returnable by 4 weeks. Miss
K Das for all the respondents.
A. Das, Learned Standing Council. Elementary Education. Accept notice on behalf of all the respondents. Notice is therefore complete. Petitioners to furnish extra copies of the writ petition within 2 days. List again on so and so.
And your next. Yes.
My lord, petitioner has been presently serving as the regular principal of Sakla Higher Secondary School, Bongaigaon district. Page 18 is the appointment order of as a principal. Pursuant to the selection process, I am a regular principal.
Okay.
Then my lord, page 20, the inspector of school has placed me under suspension for not submission of audit report with regard to collection of fees, etc. and playing the game. Thereafter, my lord, by order dated 21/12/2022, page 22, I have been placed, I was reinstated in service pending departmental proceeding. But I was not allowed to perform my duties. Thus, I have been reinstated in service. Then, my lord, page 26, the required audit report has been submitted before the authorities, and page 33, the inspector of school has requested the director to drop the departmental proceedings since there are no major irregularities with regard to maintenance of fund except few procedural lapses. My lord. Page 33, will not see. This is the report submitted by the inspector of school. I have the honor to submit here with the audit report in respect of Nur Mohammed, the petitioner, principal of Sakla Higher Secondary School, on various grants allotted to Sakla Higher Secondary School during the period of Nur Mohammed was principal of the school, to close the departmental proceeding against him. And thereafter, page 34B, page 34, the department proceeding has been dropped. With a remark that there are no, fourth paragraph, the inspector of school, EDC, Bongaigaon, submitted the audit report, which appears no major financial irregularities apart from few procedural lapses on the part of Nur Mohammed, Sakla Higher Secondary School under Bongaigaon on utilizing the fund grants received by during his tenure as principal. Page 35, accordingly, minor penalties of censure is hereby imposed upon Nur Mohammed, principal. And my lord, financial power has been taken away from me, my lord. And with a remarks that the emoluments received by Nur Mohammed, principal of Sakla High Secondary School, during his suspension period will be his entitlement. Well, I have not received the remaining part of subsistence allowance and other service benefits for the period of my suspension. But I have submitted a representation to restore my financial power. Since there are no financial irregularities, major irregularities against me, I have been reinstated in service. Departmental proceeding has been drawn and that has been also dropped. And I have only 3 years of remaining service, my lord. After 30, so many years of service, my lord, 30 years of service since 1994. So, my lord, notice may go, my lord, tendency shall not be barred to consider my.
Lordship, I just want to bring to your court's notice, your lordship, at page 34, your lordship, 34B.
Yes.
From this last paragraph, second, whereas on thorough examination, your lordship, from the last second paragraph, whereas on thorough examination, administrative inability on the part of Nur Mohammed, principal of so-and-so under Bongaigaon district has been found as evident from the records. In view of the above facts and findings, it has been decided to impose minor penalty of censure on so-and-so, your lordship.
prior to that paragraph, prior to that paragraph,
See, this is the report of
in
the
my favor.
inspector of schools. This is the report by the inspector of schools. But however, on thorough examination of the lordship, the disciplinary authority, your lordship, director cum disciplinary authority, serious administrative inability has been found, your lordship. That is why the punishment was imposed, your lordship. Also, I'll obtain instructions. Otherwise, your lordship, if in the prayer, the order, this order has been challenged, your lordship, to set aside. And under your lordship, discipline appeal rules, your lordship, there is an alternative remedy, your lordship, under 15.
Time is over now.
Hmm?
এক বছর হয়ে গেল না।
Open to file for an
So what do you say? Why don't you prefer an appeal?
Because it is now time barred, my lord, after 1 year, my lord, that cannot. There are two parts, my lord. I am challenging the punishment, minor penalties of order, and as well as to restore my financial power, as per my representation page 36.
Representation can be considered, your lordship, no?
Your minor penalty is censure only, isn't it?
Yes, my lord.
No, sir.
Though there are no major irregularities except some procedural lapse, my lord, on my part, as reported by the inspector of school, and therefore he has submitted the report to close the departmental proceeding. That has been dropped. Nothing major has been found.
Appeal will lie to whom?
Lordship,
Appeal will lie to whom?
Director, my lord.
to the secretary, your lordship,
Secretary,
government of
government.
Assam, school education,
An order has been passed by?
by
Director.
the director, your lordship. Director is the appointing authority, your lordship.
No, will issue notice then? Not Mr. N. Sharma, learned counsel for the petitioner, who submits that the petitioner is aggrieved with the order dated 8/4/2024, bracket annexure 7, issued by the director of secondary education department, imposing upon him the penalty of, within bracket, inverted comma, censure. Mr. The learned counsel submits that for want of, for not furnishing audit report, the petitioner was initially placed under suspension by the inspector of schools,
On
BDC Bongaigaon. Subsequently, after he had submitted the audit report, he was again reinstated in the service. But ultimately, the impugn order of censure has been passed against him. And at the same time, the financial powers has been taken away from him as well. We were talking about some
regarding my paragraph
area.
35, page
Area.
35, my suspension period has been regularized for pensionary benefit, but there is no mention regarding the entitlement of other benefits, subsistence allowance at the rate of 25%.
Have you said that in your petition?
Yes, my lord.
Ustad, he further submits that although
Paragraph 9, my lord.
the period of suspension has been regularized for for pension purposes, but there is no mention with regard to this entitlement for the area salaries,
Remaining part of subsistence allowance
remaining part of the subsistence allowance,
and increment, 1 year increment.
as well as increment of 1 year. Next, where I give above, issue notice of motion returnable by 4 weeks. Miss
D. Musahari, your
D. Musari, learned said,
secondary education,
standing counsel, secondary education, accept notice on behalf of
all the respondents, your lordship.
all the respondents, and therefore formal notice is not required. Petitioner to serve requisite copies of the writ petition to the Learned Standing Council within 2 days. List again on so and so.
My pendency shall not be a bar to restore my financial power as per my representation, page 36.
Tendency of the petition is not a bar for the respondents to restore the financial powers to the petitioner. You side by side.
Obliged.
They were 95 covered by your lordship's decision, judgment, my lord. Mohammed Ali's case, your lordship has disposed of.
What
They
is
are
that? Please?
page 552. They are working since 95-99 as stipendiary teacher and assistant teachers. And they were paid salary for 3 to 6, 2 years. Then thereafter, they were appointed as tutors. 552. Only time board sometime in the year 93 instead of 93, 94, 95, 99.
So what are you challenging here?
For regularization in terms of Mohar Ali's case, my lord.
Morales case.
Page 552, my lord, your lordship has passed orders.
Yes.
Same orders, my lord, it will be applicable. That is in respect of the MA school.
This is what assistant teacher in the school.
Yes. But they are stipendiary teachers and assistant teachers. They were appointed in the year 95, 99 in the district of Dhamajiman. And subsequently they were appointed as tutor. Same like this is ME school, but the present petitioners are from LP schools.
Mohar Ali Sheikh.
Or accepting my lord in the year 95, 99. And in the district of Dhamaji.
95, 99.
Yes, in between 95 to 99, they were appointed as stipendiary / assistant teachers. Actually, in fact, only one assistant teacher. In the district of Dhamaji. Rest are all. And they were initially getting salary for 3 to 2 years. Stipend, they were getting stipend salary, 900 rupees.
3 months.
3 to 2 years, man. Some person they got it for a long time. 3 months. Your lordship may write 3 months.
3 months to 2 years.
Yes.
Stipend
of rupees 900 per month.
The stipendary and what other teachers?
Only one assistant teacher, others are all stipendiary teachers.
Assistant teacher.
Yes.
In which
district Dhamaji. Rest are same.
No. At what teachers of which level?
LP school.
LP school.
Yes. And they were appointed, subsequently appointed as tutor.
Initially, they were appointed as tutor.
Initially, they were appointed as
Stipendary and assistant teacher.
Assistant teacher.
Later on, tutor.
Later on, tutor, yes. 31-21. Same like this.
Your grievances regarding your pay.
No, regularization, my lord.
Regularization.
In terms of Morales case, your lordship has disposed of the same case in terms of the same order 552. Similar cases have been disposed of. Mohar Ali case, my lord, your lordship knows about it. That your lordship will get it in at page 544. Division bench has passed the note. Here also, my lord, one of the petitioners may be allowed to submit their representation on behalf of everybody.
No, representation will be by each of them.
By, let it be
Separate.
by one. Let it by one. Your lordship has provided in same case.
No, one is regarding the copy of the writ petition.
Yes, yes,
Writ petition copy will be enclosed by one of petition
One
number
of
one,
yes,
but representation will be submitted by everybody
yes,
Individually.
individual.
individually. So can we dispose?
Yes.
I heard Mr. B.D. Das, learned senior counsel, assisted by Mr.
Yes,
S. Bora for the petitioners. Stop also had Mr.
B. Talukdar.
B. Talukdar, learned standing counsel,
Elementary,
elementary education department.
for 1, 4, 3 and 4.
Correspondent numbers 3 and 4, and Mr. R. M. Barua, learned standing counsel, finance department. Correspondent number 2. Anybody else? Having regard to the grievance projected by the petitioners, the writ petition is taken up for disposal at this stage itself. Stop. It is the case of the petitioners that they were appointed between the years 1995 to 1999 as stipend teacher, public assistant teacher in LP school in the district of Dhemaji. After working for some time, they had been what is that teacher you call it?
Tutor.
Their engagement was continued as tutors.
By an order dated 30/1/21.
By an order dated 30/1/2021.
Yes,
Correct?
yes. And they were getting salary of 10,800.
And getting a salary of
Fixed,
rupees,
fixed.
and getting a fixed salary of rupees 10,800
800.
only. Stop. The learned senior counsel submits that while the petitioners are performing similar duties and functions as that of regular teachers getting pay scale, the petitioners are only given fixed pay scale. Stop. Under the circumstance, the petitioners
Morally case.
seek for a direction to the respondent authorities to consider the case, as was done in the case of Mohar Ali Sheikh and others versus State of Assam, reported in 2024, 5 GLT 689, and which again was relied upon by this court.
Division bench.
In Mohar Ali's division bench.
His morally is division bench. 5.
Mohar Ali Sheikh
Quoted
and
in
others
another
versus State of
judgment,
Assam.
544.
and others. Okay. Just after that, you write bracket DB. And which is again relied upon by this court. In this is a bunch of similar cases that which you have annexed, which I have passed the order.
Yeah, I have given only 552, your lordship's order. Other
Fi-
cases,
5436.
the judgment is at 500.
5436.
Other judgment is by Honorable Justice R. Fukon Mehra at page 500. Your lordship's judgment is at page 552. Starts
Five-
from
Starts from
547.
in WPC number 6646 of 2025, which was disposed of on 26/11/2025. Stop. The learned senior counsel thus submits that since the present case is also a covered case, similar direction will be passed. To stop. The learned counsel appearing for the respondents also agree to the said submission. Next para in view of above. The writ petition is disposed of with the direction to the petitioners to file their individual representations before whom?
Respondent number 1.
Respondent 1.
Department of Education.
Before the secretary to the government of Assam, Department of School Education. within a period of
6 weeks.
6 weeks from today.
Well, 6 months, 6 weeks may not be in a period of 3 months, as it was provided in earlier case.
No, when will you file your representation?
Madam,
When will you file your representation?
we'll file within a period of, your lordship may say 6 weeks. 6 weeks.
Individual representations within a period of 6 weeks from today. And who will enclose the writ petition?
Well, petition number 1 or any of the petitioners?
Let us be specific. One,
Petition 1.
the liberty is also granted to the petitioners to file only one set of writ petition, which will be done by the petition number 1 before the respondent number 1.
What I propose, my lord, they will file one representation signed by everybody, enclosing a copy of the writ petition. That would be better, I think. If instead of my lord, putting so many representation. It's all right, I'll leave it.
The respondent number 1, upon receipt of the representation, shall consider and dispose of the same within a period of
3 months.
3 months from the date of receipt. With the above the observation and direction, the writ petition stands disposed of. All right.
Diploma.
This is 19. How many is left? The supplemental list, is it?
And this matter relates to the compensation appointment, my lord.
Okay.
In earlier occasion, the petitioner was approached before a lordship in earlier the petition, by which my lord lordship was given a direction that is annexed to a page, my lord. It is page number 23, my lord, by which it was direction was given to place the matter before the DLC. And accordingly, my lord, matter was placed before the DLC. DLC on approval, that was again placed before the SLC. SLC also, my lord, recommended my post to be appointed as there was no vacancy in the Lakhimpur. So my post to be adjusted in Tinsukia district, my lord. So lordship will come to annex 3 at page 33, my lord. Page 33, my lord.
Yes.
Whereby at the top of the my lord, serial number 14, where my name is there, my lord, Lakhimpur, my lord, Bindusar Kashyap. My lord, I have been recommended, my lord, that appointment, but the lack of vacancy under the IS of Lakhimpur, and the committee recommended that we adjust in the grade for post under the IS Tinsukia, my lord. And accordingly, my lord, the director also, my lord, recommended the forwarded the post to be appointed to the secretary, my lord, education, my lord, school education. And after that, my lord, the school education, that was some view was taken from the personal finance SUI, my lord, concurrence. Then and SUI concurrence was well sent, then the finance department, my lord, sent the file to the personal department in view of my lord OM that has been subsequently, my lord, pronounced in 2024. By which, my lord, the earlier the subsequent appointment, the compensation appointment, my lord, that has been substituted by another scheme that if a person died, his salary should be continued till his retirement. So on that issue, my lord, the personal department take view from the, my lord, judicial department. And judicial department also, my lord, they cleared their views. And accordingly, that was again sent back. But now, my lord, the thing is there, again, my lord, the same exercise has been trying to carried out. And the personnel department again, finance department again send the file to the my lord personnel department, their views. So from the two communications, earlier occasion, my lord lordship, the other side, the present before your lordship, by which my lord one communication that is on 17/9/2025. The copy also, my lord, available with me. My lord, I can furnish, my lord. It one copy probably my lord, in the record also. They produced by the government advocate, concerned advocate, my lord. Wherefrom it is, my lord, clear the how the file is moved from one department to one department, my lord. The second paragraph, my lord, this department received proposal from the DSC Assam on successes regarding the compulsory appointment of the petitioner, but the authority authenticated checklist was submitted by the DSC Assam on 25/3/2024. After examination of the proposal of the petitioner, this department moved the file to the finance department for SUI approval.
I've read it. I've read it. So
Yes.
who is the appearing for the department?
Well, in last, but the problem is this, the last occasion, well, another, well, the instruction that is on, well, the 5th December 2025, it has been produced by the finance department. As the finance department asked to obtain the instruction, now they are saying, that although the judicial department has cleared the things, well, as the, well, the person died, well, the 2017, and there was a, well, one policy was taken by the government that to all consider the all cases in the one go. So in that time, that was not placed, although that my SLC, my lord, recommendation was much prior to of this, my lord, the attempt was made by the government for considering all the cases in at one go. So, my lord, they seek another now opinion from the personnel department. Now the file is before the personnel department for their consideration. It is now another communication that has been I have been communicated, that is by 15 December, by which, my lord, they are trying to say that as the matter is before the personnel department, and until unless that has been, well, considered by the personnel department, this they are not able to give me appointment, my lord, in the specific, my lord, pointed post, my lord. So matter is, my lord, from one court to another is like the tennis ball is moving, but nobody is taking the responsibility, my lord. Once the court has passed an order, and what the court is ordered passed, that has been always, my lord, order. Unless and until that has been, my lord, reviewed or, my lord, nullified by any, my lord, superior, my lord, the authority or any superior bench, my lord. So they have neither filed any appeal nor nothing is, my lord, now this thing is going from one court to another.
So what is to be done?
My lord?
My lord, as per my instruction dated 15/12/2025, the finance department, as per suggestion of the finance department, the education department sent the file to the personnel department for their specific views, my lord.
This is what Mr. Counsel petitioner had said already.
Yes, already personnel department has taken their view, obtained the judicial view. Judicial cleared the things.
You are
Why
repeating
these
again.
things and again going, my lord? There should be some aim.
My lord, sometime may be granted so that I can obtain the instruction. No, financial, it is happening.
Personnel department. Personnel department.
Yes, personnel
pending.
department. Personnel department represented by government.
So you have kicked the ball to the personnel department. And you have forgotten what is what.
Finance department, for suggestion of the finance department, move the file to the personnel department.
Please write down, it is submitted at the bar that
For specific.
despite the matter having been cleared by the personnel department at an earlier point of time, the matter was referred to the finance department. And the finance department has again sought for the opinion of the personnel department. And the outcome is awaited. Such being the position that the matter be listed after the winter vacation on so and so. 19/1/2026. Ms. A. Fukan and Mr. U. Sharma. appearing for the state respondents as well as the state respondents and the Department of
Education Department.
Secondary Education respectively shall obtain the up-to-date status about the case which is said to be pending before the Personnel Department by the next date.
At least there should be some aim, my lord. This is a long, this is dragging the matters from one court to another, like a tennis ball, my lord.
Our name has not been shown and we don't have copies of.
They are not the parties, my lord.
Yes, that's why.
So I will fund it, but.
We are not a party. Then
No,
how can
no,
you
no,
make the instruction, your lordship?
One department.
Personnel Department.
Purpose তোমালোকৰ communication কৰিছে মইতো কৰা নাই. This is made by the department concerned.
Interdepartmental. committee.
Interdepartmental. This is, I am not
We
my
are-
lord.
We are not a party, your lord.
I am not supposed to make them party, my lord. Because this is
Okay,
between the,
Bring
there
the
are,
instruction, your lord.
is,
Do you furnish a copy of the writ petition?
I'll furnish one.
Petitioner to furnish a copy of the writ petition to the learned standing counsel. To the learned government advocate. To enable her to obtain instructions in the matter.
2 copies, your lord. One, I have to communicate 1 copy.
Okay, 2 copies.
Oblige.
Earlier, my lord, on the same footing, my lord, finance department, on the instruction they brought this, my lord, is subject to instructions. Now they are saying this in same thing. Problem is this one.
May I please, your lord? Lordship, here is the petitioner are unmarried dependent daughters of the government employees who were working as teacher and avail family pension from the government of Assam. Lordship, thereafter, the mother of the petitioner number 1 expired on 22/6/2013, and thereafter the family pension was dropped. And Lordship, the father of the petitioner number 2 died in the year of 2001, and thereafter the pension was dropped, Lordship. Thereafter, Lordship, petitioner submitted their application in the year of 2019 before the Treasury officer, Kamrup Amingao, Lordship, along with all documents. The Treasury officer, Kamrup Amingao, thereafter forwarded the claim of the petitioner to the Director of Pension Assam at letter dated 29/8/2029, Lordship, for necessary action. Lordship, thereafter, the Director of Pension had letter dated 27/2/2020 instructed the Treasury officer Amingao to submit the proposal for family pension of the petitioner through the concerned head office as per government notification, Lordship. Thereafter, Lordship, the petitioner approached the office of the Director of Pension to ascertain the status of their application, and upon inquiry, they were informed that no fresh proposal has been received by the said office, Lordship, from the Treasury officer. As a result, Lordship, the family pension has not been finalized. Hence, this petition, Lordship.
How many petitioners?
2, Lordship.
They are from the same family?
No,
Then why have you filed a joint petition like this?
cause of action, same, Lordship.
Maybe. If 50 people have same cause of action like this from different family, they'll file similar like that. School also is not, school also is not same, isn't it?
No, Lordship.
School also is different.
Yes.
And moreover, Lordship, may kindly peruse the last order dated, Lordship, 15/12/2025, Lordship. They filed an IA implementing the Director of Elementary Education, but they have not submitted the amended cost title to that, Lordship, nor they have submitted any
already-
copy to us. It is not reflected in the Lordship website also.
In the
In the
record-
cause list also, our name is not shown. Whether they have served the copy to us or not, Lordship.
Yesterday, we filed the amended cost title, Lordship.
The amended
It
cost
is
titles,
there in the
They
record,
filed,
Lordship.
but whether their copy has been served upon us, Lordship.
Office of decision.
The cost title, it is not shown, our name is not shown in the cost title, Lordship. Only government is so.
Third, Mr.
M. Hussein.
M. Hussain, learned counsel for the petitioners, who submits that by filing this writ petition, the petitioners are seeking for a direction to the respondent authorities concerned to grant them the family pension on account of their parents having expired. And the petitioners being unmarried daughters are entitled to receive such pension. In view of above, issue notice of motion returnable by 4 weeks. Government who is there? Mr. G. Pegu, learned government advocate, accepts notice on behalf of the respondent. Numbers 1 and 2. Finance. Ms. Barwa, learned R.M. Barwa, learned Central Council of Finance Department. Accepts notice on behalf of respondent number 3. And education, school education.
Yes, private.
Mr. SMT Chisti, learned standing counsel.
Okay.
School education accepts notice on behalf of respondent numbers 4, 5, and 6. Petitioners to furnish requisite copies of the writ petition to the learned counsels appear for the respondents today, along with the amended post title within 2 days. List again after 4 weeks on 29/1/2026, showing the standing counsel, elementary education in the cost list,
Also finance blocking.
as well as SC finance.
Deeply. Lordship. Pendency is not a bar in this lordship.
Pendency is not a bar for the respondents to mitigate the grievance of the petitioner.
Lordship kindly peruse the order dated 1/12/2025. Case relates to non-payment of salary, my lord. I approached before this honorable court earlier.
Instruction?
Instruction we have not received lawsuits. Lawsuit, this is an area salary from 2006.
No, I have my parents' current salary.
So
Current salary, for that current salary, instruction have the, this honorable court wants instruction.
yes, notice should go as this because he is not getting salary since 2006. So whether after lawsuits,
He's still working, my lord, because there is a correspondence in between director and inspector. My lord. Can you peruse the correspondence, lordship?
Notice go, let notice go. Mrs. A. Devi, learned counsel for the petitioner, who submits that by filing this writ petition, the petitioner prays for payment of area salaries with effect from 6/1/2006, as well as the current salary.
It's more in months, more.
আপনি ডিস্ট্রিক্ট ফাঁকু নকৰিব দেখোন
Huh?
ডিস্ট্রিক্ট
Oh, it was 11, finance department. Head to finance department. Oh, next.
The learned counsel submits that the petitioner is attending his duties, or her duties as this teacher in Daulasal High School.
After selection, my lord.
Hmm. And signing the attendance register regularly. Stop despite the same. Salary has been denied to her. Next, parent due for above, issue notice of motion returnable by 4 weeks. Mr. SMT Chisti learned. SC Education Department accepts notice on behalf of respondent numbers 1 and 2. Ms. RM Barua accepts notice on behalf of respondent numbers 3 and 5. Petitioner to take steps for service of notice upon respondent number 4. By registered post. Within 2 days. List again. After the winter vacation 1.
Well, the pendency of this rule, pendency of this petition, there is no bar.
Pendency shall not be a bar. Pendency of petition shall not be a bar. It's to the respondents for mitigating the grievances of the petitioner.
Yeah, obliged.
May it please your lordship. Lordship, we are aggrieved by the fact that the two parallel proceedings are going against us. One is criminal proceeding and another is departmental proceeding, lordship. Lordship, on 2/4/2024.
Is it not permissible in law?
Lordship?
Is it prohibited in law
Lordship.
to have parallel proceeding?
Yes, lordship. Lordship, the impugned, actually, we are aggrieved that they have appointed one inquiry officer and the inquiry officer has submitted his inquiry report wherein we were found guilty. Lordship, the inquiry report is at page number 29, lordship. And by this order dated 23/7/2025, we were found guilty. While the criminal proceeding, lordship, it is going on.
Which order?
Page number 29, lordship.
What is this?
It is an inquiry report submitted by the inquiry officers. Page number 30 is the inquiry report. Effective part
29.
29 and 30.
No, 30. 29 is only a
Order.
It's not even an order. It's a part of the
Yes,
copy
lordship.
given.
It is a part of the inquiry report.
Not part of the inquiry. It's a part of some, I don't know, copy forwarded to so and so. Number 3 and 4 are there.
Lordship.
Something wrong with your pagination. That's all. We are not on the same page. You are
29 is a-
challenging. What are you challenging?
29 is a continuation of 28 notification.
Yes, lordship.
What are you challenging?
Lordship,
Then,
we are
see, then
challenging
if-
this inquiry report,
If
lordship.
29 is the continuation, don't say that 29 is the inquiry report.
Yes.
Yes, lordship.
29 is not an inquiry report.
It is a continuation of the notification of page
That's
28,
what-
start from 28. Appointing the inquiry officer.
What are you challenging?
Lordship, we are challenging this inquiry report, lordship. It is at page number 30.
Please read.
It's a long order, lordship.
Page
May-
number 30.
30, lordship. May I read the page number 43, lordship? This is the effective finding. Page number 43. The findings, lordship. On the basis of the above observation, it is found that Sri Navakrishna Roy, BEO Golakganj, who was arrested for hatching a conspiracy demanding bribe through a subordinate, and in doing so has failed to maintain the integrity required of government servant and also failed to show devotion to his duty. Thus, the first charge against the DO of breach of trust and dereliction of duty in total violation of provision under Rule 3 of Assam Civil Services is established. Lowered the credibility of government and was unbecoming on the part of the responsible government servant. Thus, the second charge of misconduct in violation of the provision under Rule 3 of Assam Civil Service against the use established, lordship.
Okay, so after this, you file the representation.
Lordship, and we filed this representation on 1/9/2025, lordship.
Then any order passed?
No, lordship. It is still not considered.
This is one part. Then what is the criminal part?
And criminal part, Lordship, it is the investigation is going on.
Investigation is going on.
Investigation is going on, Lordship. No charge sheet has been filed till date.
So I don't think there's a bar.
Lordship, at this stage, a notice may kindly be issued, Lordship.
There's no bar as it is. You see, they may proceed with the department proceeding. Criminal case will take its own time. Investigation not completed, charge sheet not filed. Trial, forget, it's not yet begun also. The test also is different. Criminal will be,
Both the cases.
criminal will be on the basis of proof without beyond reasonable doubt. Departmental will be on the basis of preponderance of probabilities. And of course, you may say that it's on the same set of facts and the same set of witnesses on all those things. If everything is ditto, then there might be some prejudice to you.
Lordship, both the
But
cases arise
that
out of the
situation has
same.
not arisen now. That
Lordship,
situation has not arisen because one has resulted in an inquiry report, others is still, charge sheet is yet to file.
both the facts are as similar, Lordship, because both the cases, both the proceedings, Lordship, has
Even if you are discharged by the criminal court, you may still be proceeded against. There's no bar.
Lordship, because both the proceedings have been arisen out of the same PS case number. The PS case number 34 of 2024. It's a ACB PS case number 34.
Okay, you'll get notice this time.
Lordship,
Heard, Mr.
US Bora.
US Bora Learned Counsel for the petitioner who submits that the petitioner is aggrieved with the conclusion drawn by the department proceedings through the inquiry report submitted on 23/7/2025 by the inquiry officer. While the criminal investigation against the petitioner on the same set of facts is pending. Why have you filed this writ petition? To delay the process?
No, Lordship, because we, as per this inquiry report, we have been found guilty, and at any moment, Lordship, order rule, as per order 7, Lordship, rule 7, we may be inflicted punishment, Lordship.
You will be
Inflicted punishment, Lordship.
Contemplating punishment.
Contemplating punishment, Lordship.
that's what,
Lordship.
but it's only contemplated, not yet passed, isn't it? So
In fact, he participated in the inquiry. He has led his evidence. He has cross-examined the witnesses. He has led his own witnesses.
So you have also prayed for disposal of the representation. We'll dispose this writ petition then. Let them dispose your representation by a reasoned order. What else can we say? That is what you have prayed for.
Lordship, we are praying for stay of this. Basically, we are praying for actually interim was
Stay of what?
Stay of this inquiry report, Lordship.
Come to prayer C, page 16.
Or Captain Evans, Lordship.
You have given the court a few choices. We'll go by
Lordship,
choice C.
See,
We'll go by
still also
choice
fine,
C.
Lordship.
They'll consider and dispose it of
Lordship.
by reasoned order.
Lordship.
Doesn't mean that door is closed to you.
Lordship, we
If it's not to your liking, you may come again. Up to
Lordship.
you.
Lordship.
The learned counsel submits that although the petitioner has participated in the inquiry proceedings, but since what have you stated in your representation?
It is page number 44.
Since the criminal proceedings are yet to conclude, are yet to proceed and conclude, the respondent authorities at the same time having overlooked the vital evidence while relying upon inadmissible materials and not considering the defense of the petitioner, has the petitioner has been caused great prejudice. So accordingly, the petitioner had filed his representation against the inquiry report on 1/9/2025, which has not been considered by the respondent till date. Now, considering the above projection, instead of keeping the writ petition pending, the writ petition is disposed of by directing the respondent authorities concerned to consider and dispose of the representation submitted by the petitioner. Within a period of 1 month from the date of receipt of a certified copy of this order. Beginning part, you write Mr. B. Caution. Learned Standing Counsel. Secondary, is it?
Department of School Education, Secondary.
Secondary Education Department. IPS for
Respondent 1, 3, and 4.
not 2 also.
Sorry, 2 also.
For all the respondents.
Lordship. Most obliged.
May I praise your lordship? Lordship, this matter pertains to participating in the counseling rounds of NEET PG 2025. Lordship, the facts of the case are that the petitioner herein, he was appointed as a medical and health officer on 19/1/2023. Lordship, thereafter, Lordship, on 14/2/2023, applied for earned leave of 1 month. That was granted. Subsequently, he applied for extraordinary leave of 90 days. Thereafter, Lordship, he did not join in service. Under such circumstance, your Lordship will kindly see page 33. He had submitted a letter for resignation. Page 33 is the typed copy, Lordship. This is with reference to the subject cited above, may I, Dr. So-and-so, be excused to draw your sympathetic attention that due to my ambition of higher studies, I am bound to resign from the post of medical and health officer with effect from 14/6/2024, having been completed my allotted departmental service leaves. Now, Lordship, upon submission of this letter, there was no acceptance letter issued by the authorities. That continued. He appeared in NEET PG 2024. Since there was no acceptance letter, he could not participate in the counseling rounds. Therefore, Lordship, he had to give up his seat for NEET PG 2024. Thereafter, Lordship, he again, in the meantime, a show cause notice was on 19/8/2024, page 37. He was asked to submit his resignation in proper format. That is at page 37, the direction. Page 37, I will just read the
So
last
what's the
paragraph.
relief you're seeking?
Lordship, the relief is, Lordship, because now the rules say, if I may just place it, because when he was appointed, he was under probation for 2 years. Therefore, he was a temporary employee for that period. The rules say
Temporary employee
of the health department.
health department.
Health department.
As what?
Lordship, medical and health officer.
Medical and health officer.
Lordship. Because probation was for 2 years, he had served for 1 year, 1 month. Now, Lordship, the rules say, if I may take your Lordship to the rules, it says if the temporary employee, upon completion of his extraordinary leave, does not join in service, it will be deemed that he has resigned from service. That your Lordship will find at page, Lordship, 54. Relevant is at page 74. It starts from 54. Relevant, your Lordship will find at page 74. 74 states about the probation period. May I read, Lordship? Subject to availability of a permanent vacancy in the respective cadre, a member shall be placed according to seniority on probation against the permanent vacancy for a period of 2 years before he is confirmed against the permanent vacancy. Now, your Lordship may kindly see the leave rules. What does it state? Page. It starts from page 88. The relevant is at Lordship, page 92. The leave rules. Page 92, your Lordship will find the relevant part. 14.3, Lordship. May I read it, Lordship?
Yes.
Where a government servant who is not in permanent employment fails to resume duty on expiry of the maximum period extraordinary leave granted to him, or where such a government servant who is granted a lesser amount of extraordinary leave than the maximum amount admissible remains absent from duty for any period which together with the extraordinary leave granted exceeds the limit up to which he could have been granted under such leave, he will, unless the governor in view of the exceptional circumstances of the case otherwise determines, be deemed to have resigned his appointment. Now, Lordship, subject to what my learned friend would argue, in their affidavit, they have stated that though I had submitted my application for extraordinary leave, that was never granted. And as such, this clause will not apply. But your Lordship will see from their very affidavit at page 110, their contention is that it was never granted, this extraordinary leave. Therefore, this rule 14.3 will not apply to me. Page 110, your Lordship will kindly see of their affidavit. May I read it, Lordship? With reference to the subject cited above, I have the honor to inform you that Dr. So-and-so, that is the petitioner, under District Hailakandi availed earned leave for the period from 15/2/2024 to 15/3/2024 on his personal affairs. And subsequently, Dr. So-and-so submitted another extension period of extraordinary leave with effect from 16 March for 90 days. And this will, your Lordship will kindly see. And the leave has already expired. Now, question of expiry leave will only come when the leave has been granted. The authorities themselves say that this 90 days of extraordinary leave has expired. And the second contention in the affidavit is that
is there any order granting you leave?
Lordship?
Is there any order
Lordship,
granting you
we
leave?
had submitted the application after expiry of 90 days.
No, there's a difference between submission application and grant of leave.
No, your Lordship will kindly take up page 30 for a moment, Lordship, 30 of the writ petition.
What are you challenging here in this writ petition?
Lordship, now the issue is, I have submitted my candidature for NEET PG 2025. I have secured high marks. The condition is, if I am a government servant, either there has to be a resignation acceptance letter, if I have resigned from service, or an NOC by the department.
But you told me that you have missed the counseling.
Lordship, that was NEET PG 2024. 25 is still ongoing.
Ongoing.
You
want to resign?
Lordship, I have already submitted my resignation. Now they have neither issued any acceptance letter, And Lordship, the second contention in their affidavit, they say that, Lordship, there are two requirements now to participate in the counseling. Either a resignation acceptance letter or an NOC.
NOC.
They say in their affidavit, your Lordship will kindly see the last page of the affidavit. Page 122. May I read, Lordship?
Yes.
With reference to the subject cited above, I have the honor to inform government that Dr. Iqbal Bahar Laskar applied for resignation from government service and never applied for NOC for NEET PG as per office record of this directorate. Your Lordship will kindly see the writ petition for a moment. Page 53. Page 53, Lordship. This is dated 13/11/2025. Your Lordship will kindly see the second last paragraph. Due to non-receipt merit, Lordship.
Yes.
Lordship, I will read the second paragraph. As per the aforementioned notification, candidates serving in regular government posts are required to submit either a no objection certificate or a resignation acceptance letter at the time of PG counseling. In the absence of either document, I will not be eligible for admission to the PG course under state quota. Due to non-receipt of the NOC, I was unable to participate in the first round of counseling. As the last date of admission for the current counseling is 19 November, I most humbly request your kind intervention for expeditious processing and issuance of the no objection certificate, enabling me to participate in the ongoing counseling process without procedural hindrance. And this has been received by the Office of the Commissioner and Secretary, Health and Family Welfare Department.
When?
Lordship, this was on 13/11/2025. At the bottom, your Lordship will find.
Bottom?
Lordship, at the bottom of the page.
Bottom of the
That's
page or top of the page?
Lordship, the receipt is at 13/11/2025. It's dated also 13/11/2025.
What is that on top?
Lordship, the representation letter, 13/11/2025.
The date?
Date, Lordship. It was received also on the same day. That seal and signature is there. So their contention that I had not applied for NOC does not hold good. Now, Lordship, if I am in government service, I am entitled to NOC or my resignation because they have accepted resignation letters for others for higher education. Now, I am left in the middle of nowhere. Neither they are accepting the resignation nor granting me NOC. And I have already lost 1 year of my PG course. I could not participate in the last 2024 PG course.
So now you want them to accept your resignation
Lordship,
or grant you
for
NOC?
the moment, Lordship, what I may pray is I may be allowed to participate in the counseling process. Your Lordship will consider the materials, examine whether that resignation can be accepted or not. But at least I should be allowed to participate in the counseling.
What is the relief you're claiming? That is what I'm asking you.
Lordship, the relief I am claiming is for acceptance of my resignation because in view of 14(3), upon expiry of leave, if I did not join, it is deemed that I have accepted. And alternatively, I have prayed that if I am deemed to be a government servant, please grant me the NOC so that I can at least participate in the counseling process.
What do you call acceptance of a resignation from which date?
Lordship, from the date when the leave had expired, 14/6/2024.
But leave was granted to you or what?
Lordship, your Lordship will kindly see page 30 for a moment again. Page 30, Lordship.
30.
30. This is issued by the Joint Director of Health Services, Hailakandi. As per your EOL application, it is seen that you are on leave with effect from 15 February 2024 for 30 days. After expiry of 30 days on leave, you have applied for another of EOL for 90 days with effect from 16/3/2024. As per leave application, it reveals that your leave expired on 13 June 2024, but you have not resumed your duty till date. So you are hereby directed to report for duty immediately. So the question of expiry of leave in my humble submission will only come because in this letter and also in the affidavit filed by them, the Joint Director repeatedly contends that your leave expired on so and so. So leave expiry will only come when it has been granted. Otherwise, Lordship, that will not come into play. Now, that matter your Lordship will examine, but even if I am considered to be a government servant as on that I am entitled to an NOC, at least I should be allowed to participate in the counseling process.
Yes.
Lordship, regarding the point of resignation, we have particularly stated in page number 114
or offer affidavit in opposition.
Yes, what have you stated?
Lordship, in the second paragraph.
May I know? Now here, my lord, the government petitioner is the government employee, my lord. He is working in the health department. Now he went on leave, earned leave, my lord, for a certain period. Now without joining, he again, my lord, sought for an extraordinary leave. That was not granted. Now he wants to pursue, my lord, PG, my lord, course. For that, my lord, lordship may kindly have a look at page 120, running page 120.
120.
Yes, my lord. It is an annexure G. My lord, for the in-service employees, my lord, doctors, my lord, who want to pursue, my lord, the PG courses, they are supposed to have a, my lord, NOC from the government prior to, my lord, applying for NEET exam, my lord. May I read, my lord, para 1.
Yes, read.
It says all medical officers, he is a medical officer, have to obtain NOC prior to applying for any postgraduate degree, diploma studies, or any such training courses, without which, if they appear for interview, will be treated as misconduct of duty. In the present case, my lord, lordship will see page 122. This is a letter from the, my lord, director to the joint director. May I read it, my lord? It's 6/12/2025. With reference to the subject cited above, I have the honor to inform the government that Dr. So-and-so, that is a petitioner herein, applied for resignation from government service and never applied for NOC for NEET PG. And my lord, against him, my lord, DP is pending. He has participated. He has submitted his, my lord, reply, so-called reply. And my lord, even my lord, inquiry report has been submitted. We have sought for the approval from the APSC, my lord, Assam Public Service Commission, and they have also approved. So that part, my lord, is under process. Now, my lord, without, my lord, being a government employee without that NOC, it's a misconduct, my lord. On top of that, my lord, he is unauthorizedly absent from 2024. So, my lord, to allow him, my lord, to participate in the PG, my lord, we are not in a position. Because, my lord, it will be against our own policy.
What about page 53?
My lord, page 53. Lordship will see, may I read it, my lord? With due respect, I beg to state that I am an applicant for NEET PG 2025 under the Assam State Quota, and I am presently serving under the government of Assam and as a medical officer, medical and health officer grade 1 at Mahanpur CSC. I've appeared for NEET PG 2025. My lord, that OM says, my lord, prior to applying for, my lord, NEET PG, we'll have to have a NOC from the government. Examination and secured a rank of so-and-so in compliance with the guidelines issued by the Directorate of Medical Education Assam dated so-and-so, a copy which is enclosed herewith. I have already tendered my resignation. Resignation has not been accepted till date because there is a DP pending from the government service. The departmental process for its acceptance is currently under consideration. As per the aforementioned notification, candidates serving in regular government posts are required to submit either a no objection certificate or a resignation acceptance letter. Lordship will mark this one. It will have to be a acceptance. Just submitting a resignation is not enough. At the time of PG counseling, my lord, in the absence of either document, I will not be eligible for admission to the PG courses under the state quota. May I pause, my lord, for a moment? I placed that, my lord, last annexure at page 122. He has not even applied for NOC. He has submitted a resignation which has not been accepted. Even he has admitted that it will have to be accepted resignation letter. No NOC applied, my lord. Resignation submitted, my lord. It has not been accepted because, my lord, reason is, my lord, DP is pending. Now, may I read the next para? Due to the non-receipt of NOC, now lordship comes to NOC because he is aware that, my lord, resignation has not been accepted. Due to non-receipt of NOC, I was unable to participate in the first round of counseling. Well, let him show, my lord, where he has applied for NOC. This is the report we have from the authorities that, my lord, he has not even applied.
Now he, by this representation, he says that it has not been issued. You will have to apply. Even prior to submitting your application form for the NEET PG 2025. And this is applicable to all employees, my lord. On top of that, my lord, is unauthorizedly absent from my lord 2024. Now he relies upon a particular, my lord, provision of the leave rules. Lordship will see that part also, my lord. He is heavily relying upon that. Page, my lord, 92. The rule is, my lord, the leave rules 1934. This is his main, my lord, limp of argument.
14.3.
14.3. My lord,
Yes.
may I read just
So
the
he has already
first
read
line?
it.
No, first line, my lord, one word I will type upon. Where a government servant who is not in permanent employee fails to resume duty on the expiry of maximum period of extraordinary leave granted to him, Lordship will mark this word granted, my lord. It has not been granted. He applied, he remained absent till date, my lord, 2025. That word is granted. It will have to be granted. In that case, if he does not return and join, my lord, then it will be a deemed resignation. It is admittedly is a temporary employee, my lord. He is still, my lord, in probation. But, my lord, the leave, the extraordinary leave has not been granted. We have stated categorically in the affidavit, and no, my lord, reply has been submitted denying the same. There is a statement that, my lord, he is unauthorizedly absent, no denial. No NOC application submitted, my lord, prior to appearing in NEET PG. No denial, my lord, till date. If all are admitted, my lord, how can he be now be allowed to participate in the NEET under the state health quota? Lordship has seen that, my lord, the application at page 53. Under the state health quota, he wants to have a PG admission. He has resigned. Now, without, my lord, serving under the government, my lord, he want, my lord, to have a seat under the state health quota. That is applicable to those government employees, my lord, who has served the state of Assam. And, my lord, they properly, as per the procedure, applied for NOC. He can resign also, but, my lord, for that. And now, my lord, one more document of the affidavit. We have requested him, my lord, Lordship will see page 151. 115, my lord. Thus, it's a communication to him, my lord, by the joint director, with reference to a letter of the director. May I read it, my lord? 19th of August 2024. But before that, 114. This is a letter from the government to the director. It states that, my lord, with reference to the above, I am directed to enclose here the proposal regarding acceptance of resignation in respect of the petitioner herein, my lord, who has prayed for resignation for pursuing higher studies as submitted by the joint director of Hailakandi. It may be reiterated that mere submission of resignation application cannot be deemed as acceptance of the resignation. And under no circumstances can an employee proceed without prior acceptance of resignation by the competent authority and be absent from duty without submission of proper leave, and must not suo motu proceed with resignation without government accepting the same. In view of the above, you are requested to examine the matter and resubmit the proposal accordingly, along with all requisite information and documents, with due correspondence with the Joint Director of Health Services Hailakandi for taking further necessary action from this end. For this, you will have to join and you will have to make available all the particulars, my lord. In the next letter now, my lord, this is a letter from the Joint Director to the petitioner. Pursuant to this letter at page 114. Now, Lordship will see page 115. With reference to the above, I am to inform you that the government has treated. It may reiterate that mere submission of this is the same thing, my lord. Next para. So the proposal of your application, we have been informed, for resignation from the government service has returned to the Director of Health Services Assam and requested to examine the matter and resubmit the proposal along with all requisite information and documents with due correspondence with the undersigned. In regards to your leave application for the period from so-and-so, has communicated to the AG Assam and subsequent period of extraordinary leave application period so-and-so has communicated to the director for needful action. We have stated, my lord, in the affidavit, it has not been granted. In this connection, you are directed to resume your duty with immediate effect and to resubmit. Lordship will see, my lord, this is in his favor. And resubmit your application with all requisite information, my lord. and document as desired by the government. He has never joined, he has never submitted, my lord, all requisite particulars. And there is no denial that, my lord, this letter he has not received, or he has submitted pursuant to this letter. Even then, my lord, when DP is pending, lordship will see page 116, there is a show cause. How can, my lord, we consider his resignation when, my lord, there is a DP pending? It is at a final stage now. He
Lordship,
is a government employee, my lord, as on date.
Lordship,
He is
the-
not a student.
Lordship, the resubmission of the resignation that we have categorically stated in our writ petition in paragraph Lordship 14, that in terms of this letter, resignation in proper format was submitted on 5/10/2024. And even in the inquiry report, the witnesses have accepted that fact, that the resignation was duly submitted. That has also not been denied in the affidavit in opposition. That fact also remains. This was submitted in proper format on 5/10/2024. And DP was drawn only subsequently.
Even then.
Now,
they
Lordship,
spent,
the inquiry report was submitted on 36/2025. Till now, no final order has been passed even on the inquiry report. Now, Lordship, resignations is not accepted. DP, for no fault of mine, you are keeping it pending. On the other hand, NOC is not being granted. Your Lordship will kindly see the OM which my learned friend had relied upon for grant of NOC. Therein, there is no condition that for when a DP is pending, NOC cannot be granted. It only speaks of length of service and other factors. If on those counts my NOC is denied, it's a different factor. But for the fact that a DP is pending, NOC cannot be denied because in the OM it's not there. The very OM which my learned friend had relied upon. So, Lordship, I cannot be made to suffer on both counts. If I am a government servant, I am entitled to an NOC. I agree. If the NOC is denied on the factors mentioned in the OM, that's a different thing. Now, they have not even denied that. And to the extent that on 13/11/2025 NOC was submitted, Lordship, there is a judgment of the coordinate bench of this honorable court, wherein it stated that merely because NOC was submitted at a later stage, it cannot be accepted as too technical. And court was pleased to issue a mandamus to direct them to provide NOC.
Here, my lord, lordship will see, my lord, page 120 again, my lord. Para 3 of that OM, it says the applicant should submit the application for obtaining NOC 3 months prior to the date fixed for PG degree, diploma entrance examination through proper channel and through the controlling officer and the director of health service Assam. But here, my lord, he has not even applied.
That application is on 13/11/2025, page 53. The last-
13/11/2025, my lord, that's when, my lord, already PG results were already out, my lord.
Lordship, in that,
He cannot, my lord, as per his whims and fancies, my lord, he cannot, my lord,
Lordship,
act, my lord,
exactly.
and demand NOC, resignation, everything from the government.
We'll post the matter for hearing.
Lordship.
Lordship, the counseling process will be over. That is
Yes,
the only
you
difficulty.
cannot help
Lordship, the counseling process will be over. Lordship, my only prayer is I may be allowed to participate in the counseling. If your
Well,
lordships find that there is no merit, my seat will go thereafter. But if,
My lord,
even
that
if your
seat
lordships
will
come to
go,
a,
my lord, for other candidate, eligible candidate, my
Lordship,
lord,
if
who
your
has applied
lordships
through
come-
proper channel. And he will not come under the state health quota, my lord, I can assure you, my lord. He
Lordship-
cannot, without serving the state, my lord, how can
lordship, that
have
your
a seat
lordship,
under the state quota?
that your lordships will decide. But even if your lordships come in my favor, nothing can be done at that stage. Which is only why I am praying, lordship, I may be at least allowed to participate in the counseling. Only to that extent, your lordship will immediately take it up on reopening for final hearing. We do not have any objection to that. At least I may be allowed to participate in the counseling process.
Lordship will see page 5, my lord, his submission, my lord, 1, my lord, 2 paragraphs, my lord, small para 4. The petitioner begs to state that in terms of the order dated 19/1/2023, this is his regular appointment, my lord. Just page 5, para 4. The petitioner begs to state that in terms of the order dated 19/1/23, this is appointment letter, he has joined in his place of posting on 27/1/23. And since then, he had continuously served in capacity till 14/2000, my lord, hardly, my lord, 1 year. Thereafter, he sought for leave in the next para at page 6. From 15/2/24 to 14/3/24, thereafter, he has not joined even, my lord. For last, my lord, more than 1 year. 2 years now, my lord. And he wants everything now. He could have joined, my lord, applied for NOC for resignation. He could have approached the honorable court if it is pending before the authority. He has never done it at a very fair again, my lord, when the, my lord, counseling is to be held. He suddenly awakens and, my lord, he approaches the honorable court seeking for mandamus.
Lordship, because the authorities are sitting.
He is sleeping over his right, my lord, legal right, if at all he has any.
Lordship,
And today, my lord, keeping a seat vacant, somebody else will be deprived. And my lord, PG admissions are not like giving it to a particular college, it is subject wise. The eligible candidates who has no such dispute, they have applied, they are waiting for a seat in a particular subject according to their choice. In between, how can the petitioner be allowed, madam? When his DP is pending, madam.
Lordship,
And
under-
there is no prayer in the present writ petition, I suppose, my lord, it's subject to correction regarding DP, my lord.
Lordship,
It should be concluded within a time frame, or he is aggrieved, my lord, by delay in concluding the DP.
Your Lordship will kindly
This
see,
will go entirely against our policy, my lord.
Lordship,
And he is holding a public post. He's a doctor.
Lordship, the office
And this is
memorandum,
conduct.
the office memorandum does not contemplate that NOC cannot be issued when a DP is pending. My learned friend is
He has
relying
not
upon
even
the office
applied.
memorandum.
He has
Lordship,
not even applied.
the application is at page 53.
That is not an application. by NOC.
Lordship, your Lordship will kindly see the last paragraph of page 53. What is my prayer for issuance of NOC? If the only issue is that it was applied at a later stage, Lordship will take it up tomorrow. I will place the judgment exactly on the same point where honorable court held, this honorable court, that merely because it was submitted on a later stage and denial on that count would be too technical, and mandamus was issued to issue NOC.
No, right, tomorrow.
Lordship, I will
But
place the
whether the
judgment. tomorrow.
facts are same, my lord, here, my lord, he is unauthorized absent, that will have to be examined. my lord. If a case number is given, my lord, at least I can go
Lordship,
through
I will just keep it.
prior, my lord, to listing of the case.
Give him a case.
Yes.
Lordship, yes.
I will.
Just again tomorrow.
Obliged.
Paid for by the parties. Give the date.
May it please your lordship. So this is a case of a suspension order, which is at page 42. Inordinate delay suspended on 31/2017, lordship, page 42.
Suspension.
Suspension, lordship, on 31/2017. I was suspended with immediate effect. And this was basically because of a criminal case that was lodged against me, wherein I had finally been acquitted, and that your lordship will find at page 48. An allegation was made that I had obtained my admission into that college as a clerk, grade 4 employee, by way of forged document. Now, therein in that matter, page 48 is the judgment, wherein I have been acquitted, that your lordship will find at page 56, order, paragraph 13. I am Baneswar Das. And in the meantime, there has been no departmental proceeding against me also. No charge sheet, no departmental proceeding. I have been suspended 2017 on the ground that a criminal prosecution is going on against me, wherein I have now been acquitted. And this has also been communicated to the authorities at page 62. Still, my suspension order continues, lordship. It's been now 8 years now. Page 62, if your lordship will see, the register, Bhattadev University has communicated to the Director Higher Secondary on 17 March 2025, stating that I have been acquitted in that case. From March, now we are in December, still no action. The suspension order continues, lordship. This is why I am before your lordship.
What are you?
I am a grade 4 employee serving at Pathshala College, lordship. Serving at Bajali College, Pathshala, District Borpeta, lordship. Grade 4 employee, lordship. That suspension order, lordship, will see.
So notice will go this stage.
Or instructions, lordship, because as it is, lordship has seen, there is no reason for them to continue with the suspension. As it is, they
Instructions will
could not
take
have
some
continued.
time. Is it possible this week? No.
Notice may go and.
We'll issue notice then.
Yes, that's.
And fix a date, lordship.
Heard, Mr.
And pendency will not be a bar for them to take an action to remove the suspension order.
Already he has been called for hearing also.
Learned counsel for the petitioner who submits that by filing this writ petition, the petitioner has sought for a direction to the respondent authorities to revoke the suspension to revoke his suspension,
Yes.
which was passed by order dated 30/1/2017, bracket annexure 7. In view of the in the suspension order, there's no mention, isn't it?
Lordship.
There's no mention about the criminal case.
But in the communication, it is at page 62, if your lordship will see. Page 62, the communication.
No, this came later on.
Yeah.
In 2017, it does not say that because of your criminal case.
So the fact remains that the suspension is basically for that, basically for the criminal case, which your lordship will find at page 62, the clarification is given.
No, you were arrested or what?
Yes, he was arrested.
Yes, for 24 hours I was arrested, lordship.
What did I say last line? His involvement in a criminal case and that he was arrested and in custody beyond 48 hours. 24 hours.
24 hours, yes, your lordship.
For 9 days, he was under custody. Huh? No.
So the learned counsel submits that subsequently the petitioner has been acquitted by the trial court. And the same was communicated by the Bhattadev University through its registrar to the Director of Higher Education, Assam, on 17/3/2025. So despite that, the petitioner continues to be placed under suspension till date. Next, by in view of above, issue notice, a motion returnable by so and so. 6/1/2026.
I'm appearing for 1 and.
Mr. A.R. Hivildar, learned signing counsel, higher education.
For 1 and 2 lots.
Accept notice on behalf of respondent numbers 1 and 2. Who else?
1 and 2 only. Others.
Petitioner to take steps for service of notice upon the remaining respondents by registered post with AD within 3 days.
Pendency will not be a
This
bar for
begin
them.
on so and so, okay, the date, returnable date. 6/1/26. Pendency of the writ petition shall not bar the respondents from
Or revoking
revoking the suspension order.
Obliged, your lordship.
All right.
May I please? A limited prayer of the petitioner is to my lord, she has submitted on representation, annexure G, page 28, my lord. This is with regard to my lord, she has been appointed as subject teacher, but her first preference was at Bongaigaon, but she has been appointed as the Kamrup Metro, my lord. She has expressed some difficulties and in joining there. So and she has prayed for my lord modification of the appointment order. So this is a limited prayer.
She hasn't even joined in a first place of posting lawsuits.
And as there is vacancy in the Bongaigaon, she has asked for consideration. That's all, ma'am.
She should have joined in a place of posting first lawsuit, then she should have filed his lawsuit.
So my limited prayer is that, my lord, this representation will be taken into consideration by the DSC Assam.
Otherwise, my instruction is there is no such provision based. It was on need based this appointments were made lawsuit, where there is requirement lawsuit. That's particular subject where she was appointed, there's a requirement in the Kamrup district, so she was given.
Posting out here is on the basis of recruitment.
Yes.
First time.
This is the
First
first
time,
time.
first time,
lawsuit.
first.
He has joined in the place of posting lawsuit. And it's
Why
a
do
need
why
based
do you want to
appointment was given.
why do you want to go there?
And this is her home district, my lord, and husband's is there. This is the only this mercy
But
application.
a requirement of that teacher is a Kamrup district for that particular subject. And
No,
on the need basis
in
lawsuit. Where
Bongaigaon
there is
also,
requirement.
Bongaigaon also same subject, there is
And she
requirement.
should have
my lord.
joined first lawsuit. She has not yet
And
joined.
And private respondent has
Come
not,
before the honorable court, Lordship.
private respondent has a joined in that in that post, my lord. She has some other else she has joined under.
But your letter also is a bit misleading, isn't it?
written by-
Subject. I thought you were inspector of schools.
No.
You are
Subject
teacher.
teacher, subject teacher.
You are subject teacher.
Yes. That
The
is,
request for change of posting from inspector of schools, Kamrup Metro to inspector
that
of
is,
This-
schools,
it
Bongaigaon.
is jurisdiction.
that is called a jurisdiction, so it is. very
Jurisdiction.
mischievous,
Jurisdiction.
Written in very, very serious logic.
So what to do?
Dispose of my lord with the direction to the DSC Assam to consider the representation, that's all.
Otherwise, I have clear cut instruction for our phone Lordship that there is no such provision. At least he has not joined in the first place of posting Lordship.
So you accordingly consider and reject it then? What to do?
Yes. Yes, yes, that. Yes,
I
Lordship
heard
can dispose of.
Mr. Deep Pukasta, learned counsel for the petitioner, submits that the limited prayer of the petitioner is for allowing her to be posted as PG teacher under the establishment of Inspector of Schools, Bongaigaon, instead of Inspector of Schools, Kamrup Metro. So he submits that at the time of applying for the post, the petitioner had given the preference as Bongaigaon. And Kamrup Metro was a second preference only. Stop. He submits that the reason for preferring posting in Bongaigaon is on account of having a minor baby. And required support from the family, from her family, which can only be done if she is posted in Bongaigaon. Stop. The learned counsel submits that the petitioner has submitted a representation to this effect before the Director of Secondary Education on 14/11/2025, but the same has not been considered and disposed of. Stop. He submits that the limited prayer at this stage is for a direction to the respondent authority concerned to consider and dispose of the representation.
And my submission that it is appointment is made on a need base where there is a requirement of that particular post. That is why she was appointed in the Kamrup. That may be recorded, Lordship. And there is no
Next
such
para.
provision, and she has not joined in the post.
Mr. SMT Chisni, learned Standing Council, Secondary Education. On the other hand, submits that selection and appointment has been done on the basis of, on need basis. And that the petitioner has not even joined the state post to make such a prayer. So he further submits that as per the instructions he has received, there is no such provision for interchanging of posting as paid for by the petitioner.
One more submission, my lord, respondent number 6 has not joined in Bongaigaon district in the same subject.
But that doesn't give any right to the petitioner that he should be transferred to the.
Be that as it may, considering the pendency of the representation submitted by the petitioner before the Director of Secondary Education, the writ petition is disposed of by directing the state authority to consider and dispose of the representation with a reason and speaking order within a period of
15 days.
15 days from the date of receipt of a certified copy of this order.
Along with a copy of the writ petition, Lordship.
Petitioner shall submit a copy of the writ petition before the Director of Secondary Education, along with a certified copy of this order for the deed.
Obliged.
My lord, hearing opportunity may be given, my lord.
My lord, he is a official.
She can personally address the authority, that's all.
Then 15 days, it will be, have to be 1 month loss because.
No problem.
1 month, okay, not 15 days. What is the last line? Just read. Dispose of by directly. Speaking order. Then full stop. 1 month. Then full stop. Then you add one more line. The director shall also give the petitioner an opportunity of hearing before passing the order.
My lord, only thing that she has not joined, because she has to provide her detailed information to, so that the director can connect, contact her lordship, because she's not joined in any school.
Yes, we shall
She
provide.
will be at home lordship. So her contact information that has to be given to the director,
Yes.
otherwise she will not be contacted lordship.
Yes.
That will be difficult in contacting her lordship.
It is
What did I say? The petitioner shall submit a copy of the writ petition along with a certified copy of this order. Na? And also her
Contact details.
contact number and address.
Yes, oblige.
Oblige.
For order section 34.
That review petition. But on last occasion, Lordship wanted to see the parent order of Jagannath.
Which order?
Lordship, that I was relying in a case at page 125, which relied on this case and other cases. Is otherwise a settled position.
Paragraph?
At para 10.
Please read.
I'll just read the last 4 lines, Lordship. It is too fundamental to state that a candidate eligible in terms of the relevant routes for promotion to the post on a regular basis cannot be overlooked for the purpose of any temporary arrangement concerning the post as in the instant case. Therefore, this is the line. So in fact, for a temporary arrangement also, and this case have been regularly followed in many cases thereafter.
There is this line has been given more color later on,
Yes, Lordship.
isn't it?
I have just found today in a
It is
case of
fundamental to state that a candidate eligible in terms of the relevant recruitment rules for promotion to a post on a regular basis. How does it connote that even temporary appointments have to be qualified?
Yes, Lordship. Even for temporary arrangements, the person has to have the eligibility condition.
Now that is there, but this line actually
It has even more color later on, because in this judgment also, it refers not only to Jagannath Pegu at page 127, but also to one more.
No,
Julas
it-
Ahmed.
So it means that you see, there's a vacant post. And a person is eligible to be considered for promotion to that post on regular basis. And that person itself cannot be denied consideration even for his appointment on temporary basis, keeping in mind his qualification.
Now,
So directly, there's nothing directly out here. Everything is
in-
all indirect.
yes,
If,
that is,
if
that
he is
is-
eligible as a candidate for this post, even if we fill it up on temporary basis,
yes,
he also will be eligible.
yes, no,
But-
lordship,
But does it mean that even on temporary basis, person will have to be qualified?
yes, that is the, well, in fact,
That was spoken later on in a different judgment. This one does not mean that way.
In
My
this case also I have, which I have annexed, it is this case is much direct. The Tulumani Devi case at page 125, which says at para 5, page 127.
125.
127 is the operative paragraph. As per law,
But then it relies upon this judgment, Jagannath Pegu.
and one more, and Dulas Ali, one more. Uh, as per law, an incumbent who is duly qualified and eligible alone can be allowed to be principal of an educational institution. Further, it has been laid down in Jagannath Pegu, reported in so it has been held that even in order to hold an in-charge principal of education, the incumbent must satisfy the educational qualification and other eligible as may be prescribed for the post of principal.
Okay, these are the judgments.
Yes, Lordship, and
Where do we stand now, Ms. Musari?
Lordship, on the last occasion, they said that they have no problem if I have been given the in charge.
Whether who will be given in charge, Lordship, BTC is the authority because the school is under the BTC, Your Lordship.
You are for?
I'm for the government, Your Lordship, for respondent number 5. Because during deliberation, the issue had cropped up that, Your Lordship, there were no posts, principal posts, and we had stated that proposal has been sent. It is under active consideration, Your Lordship, for.
BTC, who's there for BTC?
The main problem has arisen because at the time of hearing, these things were not brought into the notice of the court. And it was an interim, Lordship, if Lordship sees the Lordship's order. it was
What has
just-
happened to the main writ petition?
Main writ petition is pending. I am not appearing there.
Still pending.
It's still pending, Lordship.
Who has filed that writ petition?
And one Bhaskar, Lordship, Bhaskar Das. It challenges. Huh? Huh? Don't. I said. In fact, initially on 28/6/2021, I was given in charge. Then he came and challenged this. Thereafter, this order was passed giving the inspector of schools the in charge. Now the inspector of schools did not have the required qualification admittedly. And in the
So,
case,
Original writ petitioner, what did he challenge?
this one at page 70.
What is that?
I was given the
You were given charge.
charge.
Which one is your name?
Chandana Mohanto.
Lordship, may I point out, Lordship, tomorrow, Lordship, one series of matter has been listed. One is this Chandana Mohanto and Bhaskar Kumar Das and other persons were there. Tomorrow, 18,
Yes,
before this court.
Listed for what?
very good then.
Mission.
Initially, this matter was taken. Then after this matter was taken alone as a review.
Admission.
If Lordship wants,
What is the WPC number?
WPC,
3550
yes, Lordship,
of 2021.
yes,
Is
yes.
Huh? WPC?
378.
Kumar.
But why did you write this WPC 3550 in your
Zero.
case file 2 writ petitions?
Chandana.
Huh? Bhaskar Kumar Das. WPC 378. There are a number of cases. One Chandana Mahanta is also there.
Yes, 3550 oblique.
What is this case?
So I have to
There
take
is- this
instructions.
Review petitioner is Chandana Mohanto and it
Review
was-
petitioner is Sandana Mohanto, Lordship. Lordship, it will be better if this case also is taken up with that case tomorrow. Then things will be much clear. Otherwise, admittedly, the inspector of schools has no, whoever may be between Bhaskar Das or Chandana Mohanta at 103, the seniority list is annexed. Now, whoever
So,
may be, but
if
the
if
inspector of
goes-
schools can't.
If inspector goes, it has to be either Chandana Mahanta or Bhaskar.
Bhaskar,
Either of them.
either. And see, as far as
Earlier Chandana Mahanta was holding the post.
Chandana Mohanta was holding the post.
So Bhaskar says that I should be given the post.
Lordship, that is his,
Then court says that instead of both of you fighting over it, let it be held by the inspector of school.
yes, Lordship, and basically this order was passed on the submission of the council for the state. Lordship would see Lordship's order for once. Because on 2022, at page 15, Lordship would see the learned councils has informed this court that the state level committee has its meeting 9/6 and recommended creation of required posts of principal and vice principal of 65 all the high secondary in the year 2013 in terms of Assam provincial and organization education institute. Today he admits that the matter is being considered by the government and the school education is pursuing the matter with the finance department for creation of post, and he will be able to give an up-to-date issue if a week's time is granted to.
Anyway, we'll listen tomorrow since we're not doing anything today. It is submitted at the bar that WPC number 3550 of 2021 and WPC number 1935 of 2020 is due to be listed on 18/12/2025. So considering the same that this review petition also be listed on 18/12.
Deeply.
Listen.
May please, your Lordship. Lordship, will kindly have a look, order dated, my lord, 16/2/2024 and 22/4/2024. There were some illegal appointments in BTC and the director BTC filed an affidavit saying that the records were not available. Although the same officer, my lord, terminated those illegal appointments. So in that view of the matter, this court, my lord, this Somoto IA was taken up. And there were direction to cause an investigation and initiate DP also. And a status report was supposed to be filed by the respondents before this court. 16/2/2024 order, my lord, and 22nd April 2024. Till date, nothing has been placed before you.
But what is this IA 2082?
2082 is the IA, which is
Filed by whom?
filed by the registry. It's a in re, my lord, Somoto. Pursuant to directions of this court. That, my lord, will find.
Where's the direction?
Yes, ma'am. The order starts from page 46 and relevant portion, my lord, will find page 64.
The 46 of what? Of the IA?
Yes, my lord. 46 of the IA. Sorry, my lord, lordship will kindly have page 39. Order dated 27/4/2023.
Hearing was concluded.
Yes,
Judgment reserved.
yes.
Judgment is passed.
Thereafter, yes, that judgment is also there, my lord.
Then IA,
Then this IA, page 43, my lord.
writ petition goes, then IA, how it doesn't remain?
No, this is for the purpose of determining the issue that the director, he filed a false affidavit before this court.
I understand. But the thing is that when the writ petition itself goes, where's the question of IA remaining alive?
My lord, the issue involved in this IA is not connected to the writ petition, in my humble submission. That's why,
It's not connected, but it comes out of that writ petition, isn't it?
yes, true, my lord.
During the proceeding, it is discovered something has happened. So separately, IA is branched out. Writ petition reserved, disposed of.
Yes,
IA remains as it is on its own.
yes.
Can it have a life like that?
My lord, we file, my lord, IA since disposed of, we file IAs, even if a matter is disposed of, we file some kind of IA, even the writ petition is disposed
I
of.
think there's a judgment from the apex court also that once the writ petition is disposed of, there's no question of another IA coming up.
My lord, in disposed of writ petitions also, we file IA in sometimes. It comes in the list as IA so-and-so, in WBC so-and-so, within brackets since disposed of.
No, I know, understand.
Yes, my lord. So, in that view of the matter,
In such cases, it's sometimes for clarification,
clarification,
in
some
sometimes cause, asking
subsequent
for
developments.
extension of some time, something like that.
So IA can exist. So that is, IA can exist, but the issue herein is that lordship will find page 43, para 11. The direction, my lord. Now they are to file a status report. What have they done? Because they formed a committee to cause an investigation with regard to these illegal appointments who were responsible. Now that committee was supposed to come to a conclusion and zero down who were the officers responsible and what action has been taken against them. It has almost 1 year. Para 64 also, my lord, will the final order passed by this court in the writ petition. Page 64, my lord. Last two paragraphs. Para 25, 24 and 25.
So what is to be done today?
Milord, they are to place the status report zeroing down who were the officers responsible because they have already formed a committee. My lord, will you kindly have order dated 22/4/2024.
Yes, what is your instruction?
Lordship, I have two instructions. One is of October 24, wherein the British authorities had constructed one inquiry committee regarding who is the person who is responsible for illegal appointments and other things. Thereafter, Lordship, 21 November 25, there is another instruction has been received wherein they have stated that the original records regarding which these petitions were pending is of 2002, 2003. And the original records were, Lordship, they were not getting the original records. So that's why, Lordship, we have not able to file our response in this IA, Lordship. This is the instruction last.
You file that by way of an affidavit?
Lordship.
Milord, the issue is what is the committee's finding? You have already constituted a committee and the committee has to come to some conclusion. Records not available was already there before the court.
By when? When was it available? Records not available.
They were trying to get the original records, Lordship. There's 67 numbers of illegal
No,
appointments.
no,
Lordship.
records is not available before that has been informed to the court earlier.
No, Lordship, recent instruction, this one is of 21 November
In
25. Some time may be given, Lordship, or to get the original records, Lordship.
Once you have said not traceable, then what will you do? Time for what?
For placing the records if it is traceable or available in the office, because these records were of 2002, 2003. So that.
So you want to make one more try?
Yes, Lordship.
Your instructions in your hand says that there is no records. It's not found,
Traceable.
not traceable. Yet you say you want to have another round.
Then, Lordship, appropriate order may be passed in the IA because already the petition has been disposed of. This IA is pending before this court. So.
No, let them bring the Milord conclusion derived by the committee because committee has already been formed. What the committee has found, that has to be placed before this honorable court. And if the committee is sitting idle since last year, then it's a serious business, Milord. If document containing forming of the committee was placed before the court and thereafter sat over it.
Lordship, 3 weeks time may be given. If it is not traceable, then we'll file on affidavit that these documents were not traceable as it is of 2002, 2003.
16 appointment order issue.
But original records is of 2003. order এখানে বেশি করে হয়েছে।
What is that inquiry committee constitution you are holding? Notification?
It's there, I think, mark.
Notification dated?
Notification. Marked as X.
Oh, marked as X.
Kindly peruse 22/4/24.
The date of the notification which you were passing over to me.
4/4/24.
It is already here. How many times you'll pass on that notification?
And I am saying about the instruction given by the BTC authorities.
Correct. Instruction, first of all, you say that committee is formed. Second thing, you say that records are not traceable. And that letter written to you,
Kindly peruse.
don't pass on that letter. That letter is written to you. It's meant for you only. What I'm saying is that that notification which you're pointing out has already been submitted to the court way back in on 22/4/2024.
Lordship, 22 October 24, they have stated the inquiry committee has been formed. Lordship, some time may be given, we'll file our response, Lordship, regarding.
Look, the whole intention of this honorable court in passing the order, my lord will find page 41, 7 to para 7 to para 10. Or para 9, my lord. Page 41, para 7 to 9. 9 is the para 9 is the whole idea. What this honorable court wanted to do, my lord.
Who is the authority concerned? BTC.
BTC.
Which authority in BTC?
My lord, principal secretary, my lord. He is the head of.
This is an IA recorded suo moto. So where are the parties arrayed?
Page 1, my lord.
Page 1?
Yes. Principal secretary BTC is the
Respondent number 4.
respondent 4.
Please write down. This IA has been directed to be registered white order dated 27/4/2023 as in WPC number 6328 of 2018. In view of what has been observed at paragraph number 9.
Yes, para number 9.
Of the order dated 27/4/2023.
9 and 11, my lord.
9 and 11.
Yes.
So thereafter, white order dated 16/2/2024. The respondent number 4 was directed to cause an inquiry in the manner indicated in the said order. which is in respect of identifying the persons who are responsible for causing illegal appointments and also causing loss of the records for such appointments. So thereafter, on 22/4/2024, court was informed that an inquiry committee has been constituted by the BTC by notification dated 4/4/2024. And upon being informed, court had directed submission of the status report on the inquiry contemplated by the next date. So however, no such status report has been brought to the notice of this court till date. Today, Ms.
And Chaudhary.
N. Chaudhary,
Yes, sir.
learned counsel appearing for the BTC, submits that she may be given some time to get back to the court with appropriate instructions. Stop considering the prayer. One more opportunity is granted to receive instructions. The instruction should be in the form of an affidavit to be filed by the respondent number 4 on or before the next date fixed. Let the matter be listed again on.
Much deeply obliged.
IA.
Lordship may kindly peruse the order dated 25/3/2025. The honorable court has expressed its mind in this order, Lordship.
Well, in fact, my lord, the IA has been filed.
For correction of order dated
7/12.
17/12. Where is that order?
Page 25 to 28. Prior to that, your lordships kindly look into Annexure 2, page 18 to 24, my lord. That is the initial order passed in the writ petition, my lord.
No, you take me to the correction. What is the correction required?
My lord, I'm kind, my lord. Kindly relevant portion is at page 23, paragraph 12, my lord. This is the order passed by the court in the writ petition WC 380 of 2018, my lord. Accordingly, this court direct the authority to examine appraise the case of the petitioner's school, keeping in mind the provincialization order has not been recalled and the cause of the school to rectify and deficiency, if there be any, and accordingly extend the benefit of provincialization with prospective away in terms of the Assam Education Provincialization Services Pre-Organization Education Institution Act 2017 which exercise will be undertaken by the authority with a period of 3 months from the date receipt of the certificate copy of the order. Against that, we prefer the review petition. Madam. Our contention for the review court is that the paragraph 12, this honorable case that taken into consideration different rule as well as the prospective that words, because the institution was provincialized with effect from 1/1/2013. It was established in 4/1/1978, and it since the school complied all the rules and regulation. That is why the institution was provincialized with effect from 1/1/2013 under the 2011 Act. Accordingly, this honorable court, but page 27, relevant portion, paragraph 8 of the review court's order, in view of the above, as there is no objection to respondent, present review petition is allowed. Modifying direction contained in paragraph 12 of the order dated so and so. Accordingly, modifying the paragraph, accordingly, this court direct the authority to examine a phrase. The case of the petitioner, school, keeping in mind the provincialization order has not been recalled and the cause of the school to rectify any deficiency, if there be any, and accordingly extend the benefit of the provincialization with prospective effect in terms of the Assam Pension Education Institution Act 2011. So which shall exercise undertaken by the authority within 3 months period. Our contention before this prospective effect was, since the school institution admittedly provincialized with effect from 1/1/2013, now while passing the order in 2020 or earlier order in prospective effort word cannot be mostly it is typical because we are understanding that the court will as per 2011 Act. 11 Act provides from 2001/2013. That is wrongly typographically that is why we are before your losses to correction of this order, and in fact, I file an affidavit, additional affidavit before this honorable court, your losses kindly look at the page 51 onwards. The additional affidavit is there, Here, the same issue raised before this honorable court in another proceeding, the state went on a review, review application before this honorable court. Paragraph 4 onwards, of the additional affidavit, page 52. The applicant is school, that is present school, is established in 78. According to school, continuous input in education, the definition of Bhansar primary institution given under section 2S of the Assam Bhansar Education Institution to Provincial Act 2011, which states within the comma, Bhansar primary school means a primary school imparting education up to class 5 and established by the people of the locality prior to 1/1/2006 and captured DICE information up to 2009-2010 as per Ministry of Human Resources, Government of India. This provision has complied because our institution was established way back in 1978 and as per 2S, we are entitled to get provincial. Accordingly, our name was within our name, school name was inducted in the list for provincialization, given the benefit from 1/1/2013.
We'll do one thing, we'll list it after the vacation.
Yes, Mufti.
Specific date may be fixed.
And we'll also file our counter with it.
Whatever you have to say, you say that, and we'll see. Okay. Must wait for the parties list the matter after the winter vacation on so and so. 31.
31.
Yes, why is this listed for orders?
One has already been expired, Lordship. In this case, in this context.
One is expired.
Yes, Lordship.
What about the others? How many respondents are there?
There are 3 respondents. And number three, I'm appearing, I'll take instruction lawsuit, but one has already been expired.
You appear for 3,
Yeah, I'll file my power lawsuit
4,
for response number three, present director, Suranjana Senapati. But one has already been expired, that has. to
then
be-
2. What about 2?
Two is a finance beginning.
Om Prakash,
Finance beginning to.
SSA.
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 SS. Yeah, fine. SSS is appearing lawsuit, she has filed her power. My P9.
Okay.
Yeah. Eight four, you are there, no?
So,
So
We all-
let him implement as soon as one, in the meantime, we will file our.
that will come, but power, power is sufficient?
No lawsuit.
Then
My
you file a reply,
Yes.
they say that you are contempt.
That, no, I have inquired.
Order
that-
passed in 2023, my lord. Only speaking order asks for, my lord.
That instruction,
regarding-
I have communicated with the authority lawsuit.
Respondent numbers 2 and 3 are represented and they pray for further 2 weeks' time to submit their affidavit. It is submitted at the bar that respondent number 1 has since expired. Stop such being the position, petitioner may take appropriate steps. Gives advice. This is the matter again and so and so.
Obliged.
The next case. 38, I have received an instruction lawsuit. The secretary has already written to the director lawsuit to furnish a formal proposal with requisite documents and particulars for financial implications calculated strictly in terms of the High Court, Honorable High Court's order to facilitate the endorsement seeking concurrence of finance department.
You are for a respondent.
And for the respondent lawsuit here, we have on one, is there only one respondent? Second,
So you get us updated status and file an affidavit.
lawsuit on last occasion, yes, I'll file the lawsuit.
Mr. SMT Chisti Lanet counsel appears for the sole respondent and submit that he has received some instructions, but submits that he will seek further up-to-date instructions in the matter. In view of above, this matter after the winter vacation on so and so.
Most to learn. May it please your lordship.
Yes.
Lordship, may I kindly have a look at the order dated 26/11. So was pleased to issue notice and I was directed to serve the notice upon the counsel of the advocate thereafter to file the acknowledgement before the registry I have done.
R.R. Gogoi.
R.R. Gogoi.
Name is shown.
My lord, 1512 is the office note, my lord.
Cost list SCPHE.
Yes, standing counsel, let's see.
R.R. Gogoi is the standing counsel.
Yes, yes, my lord.
He has not come today.
I have seen in some other courts, my lord, but not for this court. That acknowledgement that is on the separate family.
Somebody has received on his behalf.
Yes, yes.
No, is it his signature?
My lord, on behalf of my lord R.R. Gogoi, my lord, that was
I Kalita. FCPHE.
they're all from, they're all the standing counsel PHE.
I Kalita.
Yes, yes. I call it a D Gogoi, R.R. Gogoi.
They're not appearing also what to do.
They don't have any.
In terms of the last court's order, the petitioner has served notice upon the Standing Council PHE. So although acknowledgement has been made by the Standing Council PHE and the name is also reflected in the cost list, no one appears. List again. Vacation
Immediately after vacation.
again on so and so. 19-1.
Obliged.
Dear Lordship, service report is awaited.
Dear Lordship, we require 1 week time to issue the compliance order. That is my instruction, Lordship. I will submit the communication compliance order, Lordship, on the next day.
You are appearing?
Yes, I will file my Okalama today.
Mr. SMT Chisti, Learned Counsel submits that he has instructions to appear on behalf of the sole respondent. And he'll be filing his power and as well as the compliance report by the next date. Considering the submission, formal notice upon the sole respondent is waived. List the matter again.
After vacation, any date may be fixed, Lordship.
On so and so.
Applied.
Please, Your Lordship.
Yes.
Lordship, in this matter, we had filed an IA to implement Director of Higher Education Party in this matter, Lordship.
Any objection?
No.
Heard, Mr.
Arguhai.
R.
Arguhai.
Gohain.
Lordship.
Learned Counsel for the applicant who submits that by filing this application. The applicant seeks implement of the of Srimati Pomi Barua, ACS, Director of Higher Education, as respondent number 7
7.
in the connected contempt petition. Top, he submits that completement is necessary because she's the new incumbent,
New income.
new incumbent holding the seat post. In Mr. A.R. Tahibildar, Learned Counsel appears for the. You appear for whom?
It is notice will go there. Notice will go. This is a content, so notice will go to the new incumbent.
Now you are appearing for whom?
Now I am appearing for the content Lordship.
Appearing for so and so has submits that he has no objection if the application is allowed. In view of above, the application for implement as prayed for is allowed. I disposed of. Then in the mid, you write in view of the order passed today in IAC number 4054 of 2025. Petitioner to submit the amended cost title in 2 sets before the registry of this court within
Lordship.
2 days.
Lordship. Lordship, again, a notice was also sent to the Lordship, new incumbent Lordship.
Next para, issue notice to the newly implemented respondent number 7, returnable by 4 weeks. Steps be taken within 1 week. Is there any vacation bench? There's no time. What to do? Can you do it by Friday?
Lordship, we have also sent a notice, Lordship. We have also sent a notice to the new incumbent, Lordship. The
That
notice
is on
was
your
sent.
part. Court has to send notice. Your notice will not do. If that is sufficient, why do you come to the court?
After vacation.
We'll submit the amended cost title in 2 sets within 2 days, na? Then the rest you cut, list the matter again after the ensuing vacation on so and so.
Applied.
This.
IA has been filed, your lordship, the illegal stoppage of my provisional pension from October 2025 in wrong interpretation of
Probably.
Annexure A. Let me finish. Your lordship may kindly see page 8 of IA. The notification, how the authority has wrongly interpreted. Your lordship, notification in pursuance of so and so. May I read clause 2.
Yes,
Annexure A, page 8.
read.
The payment of provisional pension shall be restricted to a maximum period of 6 months from the date of retirement, subject to approval of the competent authority. This is in case of normal circumstances. Now, in respect of pensioner facing departmental proceeding or judicial proceeding, I am facing judicial proceeding, the existing rules shall continue to apply. That is Rule 22(1), your lordship.
Where's that rule?
Rule 22(1), your lordship, of the Assam Service Pension Rules.
Which book is that?
Yes. Page 13, this book,
13.
13, 1-3. Bottom 22(1). Rule 22,
Yes.
Sub-Rule 1. Where any departmental post or judicial proceeding is instituted under Rule 21, or where a departmental proceeding is continued under Clause A of the proviso thereto against an officer who has retired on attaining the age of compulsory retirement or otherwise, he shall be paid during the period commencing from the date of his retirement to the date on which, upon conclusion of such proceeding, final order of pass, a provisional pension not exceeding the maximum pension which had been admissible on the basis of his qualifying service up to the date of retirement, or if he was under suspension, so and so, so and so. So accordingly, I have been paid provisional pension. Now, in wrong interpretation of this notification, they have stopped my provisional pensions since October 2025, your lordship.
Any order passed?
No order passed, just simply giving the plea that this notification.
Okay,
These are wrongly interpreted this.
okay, let's come back to page 8,
Yes,
Annexure A.
yeah,
Second part, you have already submitted.
yes.
Now, the first part, this is meant for whom?
This is for the in normal circumstances, in order to prevent delay is for regular pension. During the pendency of finalization of regular pension,
In order to prevent delay.
yes, provisional pension is paid till final regular pension is fixed, your lordship.
No.
This is clause 1.
Yes.
And clause 2, first part is also for the normal circumstances. Second part, in respect of pensioner facing departmental or judicial proceeding, that is till final order.
So first part is regarding delay.
Delay in finalization of regular pension.
If there is delay, so that the pensioner doesn't suffer,
Yes, yes.
provisional is
Yes,
given.
that is the,
Then the second part again says that this pension will be only for 6 months.
otherwise they will keep finalization of the pension for years after. That's why six months.
Okay.
So they can early,
Supposing pension is not finalized, then what happens?
provisional pension.
No, the provisional pension is only for 6 months.
That is in normal circumstances.
Supposing you are not facing any department proceeding.
I am facing judicial proceedings.
Supposing
Yes,
you don't have any DP facing,
yes,
you're not facing any DP,
yes,
you are getting provisional pension, your pension is not finalized,
yes,
and you're given provisional pension,
yes,
and this rule says only for 6 months.
for 6 months.
Then after that, what will happen?
Then either they have to finalize the final pension, or otherwise I have to approach this court for finalization, for direction to finalize it.
So, no, I'm just trying to understand this provision.
Yes, yes.
First thing is delay. I think that's correct because to
To avoid unnecessary delay, yeah.
because of the delay, party should not suffer, so provisional pension.
Mm.
But this will continue only for 6 months.
6 months.
Supposing you have no DP in your against you,
Yes,
nothing against you.
nothing.
You have waited for 6 months, nothing has finalized.
Earlier it
Then this
was,
order says that only 6 months, then suddenly
earlier it was for 1 year, now by this notification it is 6 months.
pension stops.
So
So only option for you is to come to the court.
court, or they should finalize the final pension.
Now, in your case, it's DP.
Yes.
DP is pending, so.
So
if DP
till
is pending,
finalization, they will have to pay, they will not pay me the regular pension.
If DP is
and
pending,
gratuity.
if DP is pending in respect of pensioners facing department proceeding,
Yeah.
the existing rules shall continue to apply.
Yes.
The existing rules, you say it's 22-1.
22-1. Yeah, I have enclosed those in my writ petition. Your lordship, for a moment, if your lordship, can it take
Since when did you, since when did it stop?
October 2025, 2 months,
October
2025.
25, okay.
I got pension regularly from 19 to September 2025. 2019 onwards, I am getting provisional pension.
2019 to?
Yes, onward. I retired in October
To
2019.
September.
October 2019 till I got till September 2025. Abruptly, on the plea of this notification,
And this
which they have
notification,
failed to understand, your lordship, failed to interpret.
notification came only on 6/9/2025.
Yes,
So that's why that interpretation.
yes. Only,
Okay. Let me hear him,
Lordship,
what he has to say.
Lordship, I have received telephonic instruction, Lordship. They have no such order whereby it has been stopped, Lordship. So let me have the written instruction. I'll file a counter to this, Lordship. There is, according to them, there is no such order stopping the provisional pension, Lordship. So this has come for the first time, Lordship.
No such order,
Yes, Lord.
but the petitioner knows better because his account is becoming showing nil,
yes.
nil deposit.
Maybe.
That's
I
why he has
approached the
come.
treasury officer handed over me this notification saying, as per this notification. In fact, the department is also, in case of granting of provisional pension, department, there is no order for stoppage or.
When can we have it, Mr. Upamanya?
Lordship, day after tomorrow.
Day after tomorrow. Please write down. By filing this application, the applicant seeks for continuity of his provisional pension, which has been stopped abruptly from the month of October 2025 by misinterpretation of the notification dated 6/9/2025, bracket annexure A. Mr.
R. Majumdar.
R. Majumdar, learned counsel for the applicant, submits that there is no bar for payment of the provisional pension in respect of pensioners who are facing departmental or judicial proceedings, which exactly is the case of the petitioner. So in such cases, the normal and existing rules should continue to apply.
Rule
as-
22-1.
As stated in the notification dated 6/9/2025 itself. Stop. The learned counsel has drawn the attention of this court to Rule 22, bracket 1 of the Assam Services bracket Pension Rules 1969. Which provides for payment of
Provisional pension.
from the date of retirement till the finalization of the proceeding drawn. Next para, Mr. D. Upamanya, learned standing counsel, education,
Higher education.
higher education
One and two,
department.
Lordship.
You were for health department earlier,
Yes, Lordship.
now higher.
Both, Lordship.
He also.
Okay. Higher Education Department submits that as per the instructions received by him, there is no specific order as such by which the pension has been withheld. He however submits that he may be given some time to obtain concrete instructions in view of above and has prayed for list again on Friday.
Lordship, the other respondents may also obtain their instruction, Lordship, in that matter. Treasury and Lordship.
Finance will also obtain.
Finance instruction is
Miss R.M. Barua, SC Finance, as well as Miss Mr. R.K. Talukdar, learned counsel. Learned counsels are paying for the finance department and the
accountant.
accountant general
AG has nothing to do here. Finance.
respectively shall also shall also obtain instructions in the matter. All
In
right.
fact, I have been granted provisional pension as per this rule, 22(1). There is annex in the read petition.
Correct. But the thing is that that notification has comes this
Yes.
year. That has added
Perhaps I
confusion.
think they have wrongly interpreted the lower portion here.
Maybe. We'll see day after tomorrow.
Obliged.
This is your lordship in item number 43. Service of notice in respect of respondent number 456 is completed. To that effect, we have filed our affidavit as well, lordship.
In item 43.
43, yes, lordship. The dusty affidavit was filed on 10/12/25, lordship.
Lordship, I'm so, the master, Lordship.
What is your submission?
Respondent number 6.
Your Lordship, I am the respondent number 6 in item number 43.
Mr. J. Lotha, learned counsel for the petitioner.
Yes, lordship.
In WPC number 6495 of 2025 submits that notice has been served upon the respondent numbers 4, 5, and 6 by way of dusty as permitted by this court. An affidavit to that effect has been filed. Stop upon perusal of the affidavit. Notice is accepted to be complete upon respondent numbers 4, 5, and 6. Yes. Others?
Lordship, I'm for respondent number 3 here.
What is your prayer?
Lordship, I would like to file an affidavit in this item 43. And
You are standing counsel.
Lordship, I'm appearing on behalf of the standing counsel, R.R. Kaushik.
Okay. As paid for by the learned standing counsel. What is this? NCHAC
Lordship,
Not
NC
regular autonomous person.
or not national
North Kachar,
North Kachar Hills
Autonomous council.
Autonomous Council. 3 weeks time is granted for filing counter affidavit. Then who else? You are there for the next item?
I'm petitioner in item number 44
Yes.
and respondent number 6 in item number 43, Your Lordship.
All right.
Your Lordship, both the matter may be come up together, Your Lordship. And in the meantime, the interim order passed earlier shall be continued, Your Lordship.
Lordship, I would like to pay, Lordship, this item number 44, they have challenged the advertisement and they have also participated in the advertisement, Lordship.
That will be taken care of in due course.
Yes, Your Lordship.
In view of above, list this matter after the winter vacation on so and so. Tomorrow past earlier shall continue till the next date of listing.
Lordship, I think there is no interim, Lordship.
There's no interim.
There isn't.
There is no
Not
interim.
the effect of the.
Give me the other case. There's no interim here.
That record is with me only.
Okay. Interim order passed earlier in WPC number 5932 of 2025. Shall continue for the next date. I think I'll rise because I have a meeting coming up.
Lordship, estimates continued in pipeline.
Yes. Right. Other matters, you'll get a date. I have to rise.
Lordship, in item 20, after issuance of notice, petitioner has not turned up till today for last 5 occasions. Item 20. Perhaps he has lost his interest, Lordship, that petition matter may be disposed of. Last 5 occasions, Lordship, the petitioner has not turned up. 20.
What is the matter?
Lordship, he paid for service under the 10% quota of a retired government teacher, Lordship.
was a scheme in earlier lordship. Now that scheme is also not.
None appears for the petitioner when the matter is called. Same was the case when the matter was listed on 26/9/2022 and 8/11/2024.
Okay.
In view of above, the writ petition stands dismissed for default. Mr.
PP Datta.
P.P. Datta, Learned Counsel, appears for the
Secondary Education Department. Secondary Education.
Secondary Education Department.
My lord, item number 29. Kindly fix the date, day after tomorrow, if possible, my lord.
Not possible. We are having a lot of motion matters actually, na? So on your opening, we'll have it. She'll give you a date, okay, as per convenience.